The second last paragraph, Your Lordship.
Okay.
By notification dated 30th of March 2007, issued by Dr. R.N. Das, Registrar, Guwahati University, and published in the Assam Tribune dated 31st of March 2007, it was informed that the inquiry would be conducted in the Guwahati University guest house at so-and-so. In response to the same notification dated so-and-so, 5 students of the Hindi department, so-and-so, another student of the Hindi department was allegedly in the thick of the controversy. 1 representative of the Guwahati University Teachers Association and 1 witness on behalf of the university deposed before me. Dr. Achyut Sharma was all along present and he cross-examined some of the witnesses. Dr. Roy Chaudhary was absent. As such, the proceedings against him were continued ex parte. For the sake of convenience, these are the student members, Your Lordship. Thereafter, Your Lordship, since the petitioner did not,
in that page itself,
yes, Your Lordship,
the penultimate paragraph,
yes,
by order dated so-and-so, I closed evidence and decided to submit my report. However, I decided that a notice be issued to Professor so-and-so
yes,
to appear before me on Iman at there. Accordingly, a notice was sent to him under the seat.
yes,
I deemed it necessary to reproduce the letter dated so-and-so in order to show that he was given an opportunity to appear before me.
yes,
So-and-so, so-and-so. On Iman, so-and-so appeared before me and submitted. In his petition, he mentioned as follows, relevant portion. If I is under circumstance, since I am completely in dark with regard to the nature of inquiry and the charges leveled against me, I may be furnished with copies of all relevant documents, including the nature of the. You submitted a reply and you don't know.
No, I submitted a reply on 12/5, Your Lordship. The reply.
No, why have you written all these things in your letter? And I passed the following order. The president and so in response to Iman, he submitted a petition. Iman, by petition, he mentioned that the notice does not specify what charges have been leveled against us. That a charge sheet dated was issued to him by the so-and-so, whereupon he said that he has completely in dark about the nature and he requested me to furnish me copies of all relevant, including the nature of charges. Now, what was the order passed out here in WPC number 2224/2007?
Yes, your lordship would kindly come to page 61 for a moment, your lordship. That is where the order.
61.
Page 61, your lordship.
Yes.
Page 61, your lordship, the operative part of the order is at 65, the last paragraph. Your lordship.
Petitioner shall participate in the inquiry proceeding as well and shall afford all reasonable of being heard by way of providing opportunity to engage defense counsel, furnish required documents he may and a right to comment. To be precise, the counsel shall provide with all reasonable to defend this case. Then what happened?
Then what happened, your lordship, is the inquiry thereafter, your lordship, was completed in the month of October 2007.
No. Thereafter, what happened? After this order,
After this order, your lordship,
on 16/5/2007,
yes.
then what happened?
Thereafter, your lordship, then what happened was that, your lordship, the notification dated 30th/3/2007 was floated in the Assam Tribune.
Kindly come to page 90.
Yes.
Accordingly, the following
Yes, the
witnesses,
following
namely
witnesses.
so-and-so, were cross-examined. After cross-examination of the witness, I gave Mr. Soy a chance of hearing in writing, which was submitted on so-and-so. Now, this is the cross-examination has been done. Then what is the problem?
Your lordship, has a
Mean
certain-
to so-and-so, actually 4, 5, 6. These were the 6 persons.
this was this, in fact,
These
there's,
were the 6 person SI1 to SY6.
yes.
Then?
So in fact, there are certain details I want to point out, your lordship.
No,
My lordship,
all these people have been all along. Mintu Kolita, Babul Borua, Aparajita Dekha, Dinesh Kolita, Kobita Nath, and Vishwanath Das were cross-examined. After the cross-examination, I gave so-and-so a chance of hearing. Then where is the question of natural justice being violated?
Yes, your lordship would kindly come to, for a moment, your lordship, page 77. Your lordship. Page 77 of the inquiry.
Or why?
No, your lordship, there are certain factual instances, your lordship, surrounding the entire departmental proceeding which had happened in a certain manner.
No. After the order being passed on 16/5/2007, you were given an every opportunity. We are not concerned to go back to that further. After 16/5/2007, you were given the opportunity to cross-examine,
Yes.
to engage the defense counsel. You were given all the documents to that effect.
Yes.
Then what happens? What is the natural justice which have been violated?
Then, your lordship, thereafter, the inquiry report was not made public. Thereafter, I had filed an appeal for revocation of the suspension order along with, your lordship, that appeal was made
No.
fixed.
After this inquiry report has been given,
Yes, your lordship.
these were not given, then did they give you a chance to reply to the inquiry report?
Yes, in fact, I had submitted my reply on 15/12/2007.
Then where is the question of not made public?
It was eventually made public after a period
No,
of
no.
4 years.
How is it relevant?
It is relevant in the fact, your lordship, just a small submission in this matter.
The inquiry report which was given, there
Yes.
was a show cause given to you.
The show cause, your lordship, the charge sheet was given. There was no show. The show cause, your lordship, was
No.
not
After
filed
the
on-
inquiry report which has come, you
Filed
have
on-
been given a representation. You have been given the year that to show the
Yes.
lacunas in the inquiry report.
Yes.
For that, you have submitted a representation.
Yes.
And pursuant to that representation, what has happened?
There was a punishment which was eventually meted
So
out,
this
your lordship,
punishment has happened. Then,
at page 134, your lordship,
yes, then
and page 135.
what is wrong with it?
The-
So, natural justice has been duly complied with, as well as also the question of all this 311 has also been taken note of. So what it means?
What has happened, your lordship, will kindly go into certain details which I deem it may be relevant for your lordship.
What is relevant?
Yes, your lordship, I'll just read out the relevant portion. On page 76, I'll read out, your lordship. I'll read out.
Why?
Your lordship, the situation, the circumstances which led to the entire initiation of the 3-man inquiry
No,
committee.
let us assume.
Yes.
You see, the 3-man committee
Yes,
was only for the purpose of deciding as to whether to go ahead with the proceedings under departmental proceedings or not. The Assam Discipline and Appeal Rules does not mandate that for the purpose of initiation of a departmental proceedings, which is otherwise there in the CCS,
Yes.
a show cause notice even has to be given.
Yes. Yes.
If you see Rule 9(1), Rule 9(2), it categorically mandates that they can give the statement of allegations. So the three-man committee has no business out here. Now there is an inquiry officer has been appointed.
Yes.
You say that initially you did not know there was a publication out there in the Assam Tribune out there where your name was not mentioned. The Guwahati University says out here that, look here, we didn't mention because this would have embarrassed the teachers who were there, the two teachers,
Yes.
where we have not.
Yes.
Be that as it may.
Yes.
The inquiry officer initially was not inclined to give you a chance of further cross-examination or a defense counsel because it is for the departmental inquiry proceeding authority to do so. So you move the High Court. After moving the High Court passes an order on 16/5/2007.
Yes.
Whereby there is a direction out there that you have to be given all available opportunity. Pursuant thereto, you have cross-examined, you had your own counsel, you have submitted everything to that effect, and there is an inquiry report. So there is no question of violation of natural justice there, till there.
Yes.
Okay. Thereupon, you have also been given afforded the opportunity of submitting a representation pointing out the lacunas in the inquiry report. It is not the case yet that you did not have. It is the inquiry report. You had the inquiry report, you submitted your representation. Pursuant to the representation being submitted, this order has been passed. Now, it is in that background, you have to tell me what is wrong with that.
Your Lordship would not.
More particularly when you did not file an appeal on the 11th.
In fact, Your Lordship, this for efficacious remedy, it was more pertinent that I reproached this honorable court because I was retired on 31st October 2011.
Huh?
I had retired on 31st.
How does it matter? 2011. Why didn't you go in the appeal
In fact,
at that point of time in section 11 or rule 11 was clear?
In fact, if Your Lordship would kindly see, the inquiry report was prepared in the year 2008, whereas the punishment to me was meted out in 9/4/2011, just 6 months prior to my termination.
That is,
My resignation.
for all this while, did you get your suspension or subsistence allowance? You were kept under suspension.
I was reinstated, in fact, Your Lordship. I was reinstated.
So you were reinstated when?
I was reinstated, Your Lordship, as per 7/9/2009 of page 71.
So you were reinstated. So it is well and fine that this has happened. So you should have filed an appeal against that if you are to go on to the question of facts. This court can't go into the question of facts unless you show a perversity out there.
In fact, Your Lordship, the inquiry report 2008 accompanied the show cause, which was served on me on 5/1/2010, which is after a lapse of 2 years. So I did not even know if there was an inquiry report in existence at the time when I was reinstated. Your Lordship. That is one of my prime doubts.
So how does it matter?
Yes,
How does it matter? How are you prejudiced?
Your Lordship, I am just intending to show certain.
No, I would have understood that
yes.
without the inquiry report, they have passed this office order.
Then it will be a
Then obviously there is a violation.
Yes, yes.
ECIL comes into play. But otherwise, where is the violation out there?
Your Lordship would see that
You had the opportunity of submitting your representation. You have submitted. Matter ends thereafter. How can this court go any further into the facts or any other facts out there?
In fact, if Your Lordship, my last leg of submission here, subject to Your Lordship convenience, would be the fact that there is a pattern of behavior here, which is very much discernible of the authorities against the petitioner. If Your Lordship kindly permits me to point out that for a moment, Your Lordship, the inquiry report, Your Lordship, page 76 for a moment. If I be permitted to read.
Again, why are you going back to 76?
The reason is it lays down the reason as to why the entire proceedings were initiated against me of the first count.
No. I understood.
There was a
Let us assume that the initiation was it didn't have the factual basis.
Yes.
Let us assume.
Then Your Lordship would go into it. Your
No.
Lordship.
Let us assume that the initiation did not have the factual basis. But it has come, there's a finding to the effect that the charges have been proved against you.
The charges have been proved against me.
So once the charges have been proved against you,
yes.
What remains?
In fact,
How can this court now go into? It is something like you are now challenging initiation of a criminal proceedings when you have been already convicted?
Yes, absolutely, Your Lordship. I cannot disagree with Your Lordship's observation. The fact of the matter remains that there was a certain pattern to the entire initiation of the inquiry, which we have in fact stated in the pleadings also that Your Lordship might go in. There was an entire university of students. The issue here there was of getting marks relative to somebody else, some individual who has gotten higher marks, an individual who has apparently been shown to be favored by the petitioner. Thereafter, there was a huge ruckus outside the VC's office.
Mr. Counsel, these are all allegations which have been proved against you. You know the limitation of this court. It can't go into those unless you can show on the face of it the
Yes.
charges which have been said to be proved is on the face of it perverse. Can you show that?
I cannot do that.
Then the problem arises there.
Yes.
And these factual aspects can only would have been dealt with in appeal. Yes, Mr. Fukun. What about he is only worried about number one. We told 3 increments. Rest is nothing to do. Understood. The appeal is there. All these things are there. But he's only on this increment because if these increments are given, not giving anything, but his pensionary benefits should have been better. That's all. Isn't it?
That is my only.
Now, we told his re-employment, he's not touching on that. This has already become infructuous. Because now I think he will be 74.
72, 73, something like that. Yes.
You have filed the petition when you were 60.
60. Yes.
So now,
12
after that was in 2011.
12
Now,
years,
12 years, 72, 73 he will be now. So under such circumstances, these two has no basis. Now, 72, he cannot go for re-employment or he cannot have anything as regards headship of a department or any examination duty. Those things are gone. And the period of suspension has been treated as on duty. So that has been taken care of.
By this subsequent, yes, by the last.
So
order.
this line it has taken care of.
Yes, yes. In fact, the last portion beyond 2, 3, and the last paragraph, Your Lordship is very correct. Your Lordship, it's been taken care of. The only the operative portion which survived is the pensionary benefits that are still getting.
You have to now argue on the question of proportionality of one. Can you do that? Other two to go on, but as regards one, the proportionality.
Yes.
Isn't it the amount of a minor punishment?
It is.
When the charges have been proved.
In fact, this comes into 7 less than
So it's an increment, it will come under 7-2.
7, 7-2, Your Lordship.
Isn't it? 7-2.
Increments are proposed.
It's a minor penalty.
It's a minor penalty which has been.
So then what is wrong? How can this court now touch on the proportionality? I would have understood that you have been dismissed or reduction in rank. Then the question of proportionality could have been gone into.
Yes, yes. In fact, there is also the aspect of point number 2, which is also a major penalty, but that is no more relevant, Your Lord. After superannuation, at the re-employment at the age of 60.
And this today, I can't do anything.
Yes, no, absolutely. Your Lordship is very
With
correct.
72 years old, I can't do it.
The only crux where I can argue before this honorable court is the fact that the entire proceeding, again, Your Lordship is very correct, that everything has been reported to me as per the rules. Opportunity was given to me. But the entire initiation of the inquiry started from the entire ruckus, started created by students of the university in front of the VC's office. That became a national news, which is there itself in the inquiry report, Your Lord. Which is there itself in the inquiry report, 76, page 76, Your Lordship. In fact, the petitioner was also beaten up on stage.
Hmm?
The petitioner was beaten up on stage, Your Lordship, which is at page 76, second paragraph.
Beaten up on stage.
Yes.
By?
By, Your Lordship, assaulted, which was joined by other students. If I may be permitted to read 3 paragraphs, Your Lordship, from page 76, the second paragraph.
Mr. Sharma,
Yes.
there are two things. If this court passes an order, this court is going to uphold the inquiry. Would that be in your interest, or saying that this matter has become infructuous would have been be matter? Why I'm saying is
Yes.
this:
Yes.
it would become the court, a high court, giving a stamp of authority.
But I understand, Your Lordship.
Would that be better for him?
I'll leave it to Your Lordship. Your
No,
Lordship.
no, I'll not leave it. I leave it to you now. This court is otherwise going to dismiss it.
Yes.
Dismissing means it is going to put an author stamp of approval to the inquiry report.
On the inquiry.
The inquiry report shows that there has been certain allegations which have been proved against you.
Yes.
That there has been certain favors being done to some students.
Which will be approved by this honorable court in this order. Yes.
This court will be putting a
Yes.
stamp of authority. Do you like it? At the age of 72?
Being infructuous also.
No, there's no question of instructions. This is a
Yes,
2011 matter. There's no instruction.
instruction. In fact, the man, we're not even in touch with the client frequently now. But I understand Your Lordship's query. In fact, my leg of discussion is something that would not hold water in this court. Absolutely. I would have gone outside the ambit of the inquiry report and argued on behalf of certain other extraneous factors that Your Lordship will not. These are not in the pleadings also.
No, I can't go into
Yes,
those.
Your Lordship will not. stride
Because
out of-
going out there
Yes.
will be
Yes.
touching on various aspects of the matter, which will be. Now, the
Yes.
question of natural justice, I would have understood.
Yes.
If at that point of time the inquiry officer had submitted the report and there was no order of 16.5.
Yes.
With that order of 16.5, you have given all the opportunities.
I was also given a defense counsel.
So the question of any further, violation of natural justice does not arise.
Right.
Hello, let me.
I'll leave it to Your Lordship with all
Okay.
due honesty and
এই
sincerity.
নাম কেইটা লিখি দিব দেই আজিকালি বেলেগ ধৰণকে মোৰ জাজমেণ্ট হয় The present petition arises now. The present petition has been filed by the petitioner challenging an order dated 12/4/2011. 12/4 or 9/4?
Your Lordship, the punishment is of 9/4, 12/3, Your Lordship. 12/3 is the EC resolution.
What 12/3?
Last page, Your Lordship, page 135.
Challenging the order dated, challenging the
Punishment dated 9/4/2011. Annexure 10, Your Lordship. 9/4.
page
Page 134.
134. I've seen.
Yes.
This is the 9/4.
9/4, Your Lordship.
And then down below it is 12/4. See the order?
Yes, Your Lordship. There are two dates, Your Lordship. 9/4 and 12/4.
Challenging the order dated 9/4/2011 oblique 12/4/2011, whereby the register Guwahati University have imposed penalties upon the petitioner as enumerated therein. Next. The facts of the instant case, as would be apparent from a perusal of the repetition of the perusal of the pleadings before this court, is that that on 21/8/2006, a charge sheet was issued against the petitioner.
It's conducted moral.
Alleging charging the petitioner with gross misconduct and moral turpitude and being unworthy to remain as a teacher of the Guwahati University. The petitioner was asked to submit a reply to the said charge sheet within 10 days from the date of receipt of the said 10 days from the receipt of the charge sheet. And the petitioner was also granted an opportunity to inspect any document if he desired within 7 days from the date of receipt of the letter, with prior intimation to the registered GU. And it was also made clear that the petitioner thereupon had to file his written reply within 7 days from the date of inspection. To the said charge sheet, the statement of allegation was also enclosed. The petitioner submitted his reply, a detailed reply on 11/9/2006. It reveals from the records further that on 31/3/2007, an advertisement was published in the Assam Tribune, whereby it was informed that an inquiry would be conducted in the Guwahati University guest house at 11 a.m. on 19th, 28th, 21st, 23rd, and 24th of April 2007. This advertisement was issued by the Register Guwahati University. On the basis of the said, pursuant to the said advertisement, an inquiry proceedings, an inquiry of proceedings pursuant to the said advertisement, an inquiry proceedings was initiated, and Dr. Y.K. Phukan was the inquiry officer. It reveals from the records that initially the petitioner did not participate in the said inquiry proceedings. And it is the case of the petitioner that he had no knowledge that the said advertisement was in respect to the inquiry, was in respect to the charge sheet so submitted against the petitioner. In the meantime, in absence of the petitioner, the inquiry proceedings proceeded. And the learned inquiry officer thought it prudent prior to closing the entire inquiry proceedings and submission of the report to issue a communication to the petitioner.
2/5/2007.
For which on 2/5/2007, The learned inquiry officer had issued a communication to the petitioner to appear before him on 5/5/2007 at the Guwahati University Guest House. The petitioner, upon receipt of the said proceedings, a said communication, appeared before the inquiry officer and submitted a petition on 5/5/2007 stating inter alia that he was completely a dark as regards the initiation of the inquiry proceedings, and he would like to take the help of, and he requested for various documents, and also requested that he may be allowed to allowed the assistance of a defense, what do you call it? Defense assistant?
Yes.
Defense counsel. What is that term you use there?
It's the term is defense assistant.
Defense assistant. Assistance of a defense assistant. The inquiry officer initially refused, for which the petitioner filed a writ petition before this court, which was registered and numbered as
2224 of 2007.
2224/2007. This court, by an order dated 16/5/2007, disposed of the said writ petition with the following directions, which are reproduced herein under page 65 of Pabode. Page 65 of Ronga Kori today, taking underline, taking it on. The petition as well part of the court. The petition today. Pursuant to the said order passed by this court,
But there's a pleading, there are no connection. Pleading, your lordship, is at page 11, page 7, your lordship, that thereafter the inquiry proceeded against the petitioner, where he participated. And on 29/9,
no, I have seen it. This court, the petitioner was furnished the relevant documents, and he was also provided the assistance of a defense assistant. All the witnesses except one Srimati Krishna Rani Hazarika was cross-examined by the petition, by the counsel for the defense counsel for the petitioner. It is relevant to mention that Srimati Krishna Rani Hazarika did not say anything in her deposition against the petitioner. Pursuant thereto, the inquiry report was submitted
Before that, there was the petitioner.
Whereby it was held that charge number 3 was partly proved.
Your lordship is stating the charges, your lordship. Fully proved were 5, 6, 7,
Charge number 5 was fully proved.
6, 7, 8, and 9.
Charge number 5, 6,
7, 8, and 9 were proved,
6, 7, 8,
and 9
and 9
were proved.
were proved against the petitioner.
10 and 11, no clear finding. Yes.
It further appears from the records that the petitioner was afforded an opportunity to submit a representation against the findings of the inquiry report dated 14/2/2008. And the petitioner duly submitted a representation on 3/3/2010 in that regard. Pursuant thereto, on 12/3/2011, a decision was taken in the Executive Council by resolution number R/EC-02/2011/26 capital dated 12 whereby the following penalties were imposed upon the petitioner under section 10 of the Guwahati University Teachers Conduct Rules 1984. The said penalties are enumerated hereunder 1, 2, and 3, page 134 of property. 1, 2, and this decision of the Executive Council was duly communicated on the basis of an office order dated 9/4/2011 issued by the Register Guwahati University, which have been assailed in the instant proceedings. From the perusal of the above, a 1, 2, and 3 are today common lecture. 1, 2, and 3 are itolot. From the perusal of the punishment so imposed, the penalties so imposed, it to transpire that number 1, there would be with that 3 increments. One on 1/7/2007, second on 1/7/2008, and third on 1/7/2009, with cumulative effect would be withheld. Roman 2. The petitioner's re-employment after superannuation at the age of 60 was withheld. And number 3, the petitioner would not be given any administrative responsibility, particularly in respect of his headship of her department, and any examination duty till he continued to remain as a teacher in the university. It was however mentioned in the said office order that the period of suspension from 27/2006 to 29/11/2009 shall be treated as on duty. At this stage, this court finds it also relevant to take note of that with effect from 30/11/2009, 30/11,
31/10,
31/10, it can't be there. He said the suspension was only till 29.
Yes, 2010.
So with effect from, this court also finds it relevant to take note of that with effect from 30/11/2009 till when with effect, the petitioner was reinstated to his service. And the petitioner retired on
31st of October 2011.
31st of October 2011. The petitioner being aggrieved by the imposition of penalty by the office order dated 9/4/2011, which is on the basis of the EC resolution dated 12/3/2011, have filed the instant writ petition. At this stage, filed the instant writ petition on 7th of June 2011. It appears on record that on 26/2011, notice was issued making it returnable. On 22/7/2011, although notice was also issued on the interim prayer, but there was no relief, no interim relief granted, save and except an observation being made on 30/9/2011, wherein it has been mentioned that pendency of the writ petition shall not be a bar for the respondent university to consider the case of the petitioner for extension of service beyond the age of superannuation as per law. It reveals from the records the respondent number 1, 2, and 3 have jointly submitted an affidavit in opposition stating inter alia that the allegation that that there is no infirmity in the inquiry proceedings and the punishments so imposed and the penalties so imposed was proportionate to the charges proved against the petitioner. To the said affidavit in opposition, a reply was filed by the petitioner. Full stop. I've heard the learned counsels for the parties and have perused the materials on records. Mr. M.K. Sharma,
M. Shah.
M. Sharma, the learned counsel appearing on behalf of the petitioner, at the outset had submitted that taking into account the pendency of the writ petition since 2011, the instant proceedings and the petitioner at present being at the age of being at present would be 72 years. The penalties at serial number 2 and 3 of the office order dated 9/4/2000, the challenge to the penalties at serial number 2 and 3 of the office order dated 12/9/2011 has already become infructuous. The learned counsel, however, strenuously argued that the inquiry proceedings so initiated, as well as the manner in which the inquiry of proceedings was conducted, was in violation to the principles of natural justice. The learned counsel submitted that the very initiation of the inquiry proceedings on the basis of a report being submitted by a 3-member committee, wherein the petitioner was not given an opportunity to be heard, was contrary to the principles of natural justice and accordingly violated the mandate of Article 14 of the Constitution. The learned counsel further submitted that the inquiry proceedings, what else you have?
So, in fact, I had proceeded to also crux my submission on the surrounding circumstances which initiated the entire proceeding against the petitioner.
Inquiry proceedings, what do you have to say? You can't say anything.
That belatedly, Your Lordship, I was given an option of cross-examining.
How does it matter? You got the right of cross-examination.
But initially, when the inquiry report was initially compiled by the inquiry officer, I was not given a chance of attendance. I was not given an audience, and the inquiry.
Understood, but you got everything.
Eventually, I got everything.
Then how does it matter?
Eventually, the inquiry.
He further submitted that the inquiry proceedings, that the petitioner was granted an opportunity. Though granted an opportunity, the petitioner, though granted an opportunity in the inquiry proceedings, was belated. And this had prejudiced the petitioner.
It was only at the instance of this honorable court's interference.
That is too much. This would show a very poor judgment on you to make that submission. That I won't put it if it is made on records.
Apologize.
On the other hand, Mr. P.J. Phukan, the learned counsel appearing on behalf of the Guwahati University, submitted you come under the Assam Service, Discipline and Appeal Service. Huh? And I took submitted that the instant repetition is not maintainable, as the petitioner did not avail a remedy, the appellate remedy available to him under Rule 13 and 15 of the Assam Services Discipline and Appeal Rules 1964, for short, the Rules of 1964. The Learned Counsel further submitted that for initiation of a departmental proceedings, the mandate of Rule 9, there is no requirement in terms with Rule 9 that an opportunity is required to be given for initiation of, before initiation of a departmental proceedings. The Learned Counsel further submitted that the statements of allegation, that the charge sheet as well as the statement of allegation was duly submitted, and the petitioner was given all opportunities in that regard. Full stop. Further to that, the Learned Counsel submitted that pursuant to the order dated 16/5/2007 passed in WPC number 2224/2007, the petitioner was granted each and every all opportunities to defend his case before the inquiry officer, and as such, the question of violation of the principles of natural justice does not arise. The Learned Counsel further submitted that there is the judgment that the perusal of the inquiry report would further show that the inquiry officer have duly taken into consideration each and every aspect of the matter, and as such, there is no question with the interference with the inquiry proceedings. The penalty so imposed, more particularly the penalty which is at stake at the present proceedings in the penalty so the Learned Counsel further submitted that the penalty so imposed is also proportionate to the charges proved against the petitioner, in as much as the petitioner, in as much as in view of the charges so proved, the petitioner was actually not fit to be retained in the services of the Guwahati University. Upon hearing the Learned Counsels for the parties and giving my anxious consideration to the matter, let this court therefore take into consideration each of the submissions. The first submission so made by the Learned Counsel for the petitioner, that the initiation of the inquiry proceedings on the basis of a 3-member committee report without granting the petitioner an opportunity of hearing is totally misconceived, in as much as Rule 9 does not emphasize that Rule 9 of the Rules of 1964 does not emphasize that prior to initiation of a departmental proceedings, an opportunity of hearing is required to be given. Full stop. The second submission which have been made by the Learned Counsel for the petitioner, that the petitioner participated in the said departmental proceedings at the instance of the court orders passed by this court on 16/5/2007, and that too belatedly, which has prejudiced the petitioner in the opinion of this court, is also totally misconceived, as from a perusal of the inquiry report, the petitioner was given each and every opportunity in as much as the petitioner was furnished all the relevant documents. The petitioner was granted the permission to have the assistance of a defense assistant, as well as also the petitioner was The petitioner was permitted to cross-examine each and every witness, and the petitioner was also heard prior to the passing of the inquiry report. Full stop. Under such circumstances, this court is of the opinion that the inquiry report cannot be said to be of any infirmity. Now, coming to the question as regards the penalties so imposed, this court is further of the opinion that taking into account the charges which have been leveled against the petitioner, the penalty at present, the penalties so imposed are proportionate, and as such, the question of interference with the penalties does not arise. Interference with the office order dated 9/4/2011, whereby the penalties have been imposed upon the petitioner, does not arise. Consequently, this court, therefore, finds no merit in the instant petition for which, and accordingly, the petition stands dismissed.
I'm grateful.
Who is appearing in item number 1? No. Yes, Mr. Ahmed, you are appearing in which item? Let us take up 5 first.
No 5.
Then I'll take.
May I please, Your Lordship?
Yes.
We are going to withdraw this matter and we are not pressing this anymore.
Okay, heard, Mr.
You, Nanda.
I do. I naam to enake deputy.
SC Vishal.
You give it in the slip, huh?
Okay.
The counsel for the petitioner submits that the petitioner does not want to press the instant petition. Accordingly, the petition stands dismissed on withdrawal.
Obliged.
At number 6.
Yes.
This is an application, Lordship, for non-payment of lump sum differential amount to the petitioner when
You are challenging a clause,
yes, Lord,
clause 7.
it's clause 7 of the notification.
Yes. Why?
Lordship, I have been working in the company for the period for which they have given the lump sum differential amount. I have rendered
Why did the company give the lump sum differential?
lump sum differential amount has been given as because this is the company which is the upstream oil companies, and the downstream oil companies have difference in the salary. So as the salary has not been fixed up till 2006, so the company has given this differential lump sum amount to compensate them.
Is it so? Then why is it only given for those people who died? Superannuation, voluntary retirement,
And
but not for resignation.
And also, Lordship, because of this lower amount of salary, lots of people has left the company.
And you
why
are one of them. You are
I'm one of them.
Then that's their policy decision. What the case you have?
Lordship, that is right. But it is
If
admitted,
it is right, then nothing survives.
Lordship, because I have before the court for the lump sum amount which has been given for the service which I have rendered for the company, not for anything.
No, but the thing is, you have resigned.
The Lordship, I have
It is a
resigned.
policy decision by them. Why they have given only to those category of people? Why should this court sit over it? What is the violation? They have a policy decision. They look at those people who have died, those people who have superannuated, those people who have left only as per their will or voluntary retirement also, where the other side has the option of saying that don't leave or anything. Yeah, you are a case of resignation. You have left.
I have left.
Then,
Lordship. That is
it
admitted
being
I
the
have
policy
left, but-
decision, why should this court at all interfere?
Lordship, but the service which I have been rendered to the company will for that only they have given this lump sum amount. Not
No,
for,
not for that. The reason is to put a check. Initially, there were a lot of people, 50 to 70 people who left, including you.
Yes.
After this thing which has come in, this policy decision which has come in, only 5 or 9 or 10 person have left. Yeah. They wanted to keep a check because otherwise the national company is going to be without precious people. You went to Kuwait company, Kuwait oil company.
Wait,
Then you are in Kuwait.
now, Lordship, I am in India, and now in
Eh?
Assam only.
You went to Kuwait. Now you are fighting.
I am fighting from 2011, Lordship.
Understood.
Lord.
But the fact is this: you must have retired now. That is why you are back.
No, I
Or,
have taken, I
is
have
it
taken
because
the
of the
beers.
Kuwait war?
I have taken the beers, Lordship.
Kuwait war.
And no, from the Kuwait Oil Company, I have joined in India in the Crank India Private Limited. Therefrom, I have taken.
Because of the Kuwait war? No. Oh, now too, there is no problem. Nah?
No.
You left in 2006,
2007.
7.
2000.
So at that point of time, the war
There is
was over. That happened in 92.
I have come back from the Kuwait Kuwait company and joined in India after that.
You have again come back and join here.
No, not in Oil India, in other.
But you don't have a case. Policy decision.
Lordship, only the thing is that the service which I have been rendered to the company.
No,
For
no,
so
the
many-
thing is, it
That-
was
that is
their
admitted.
policy decision.
Lordship, it's a whether that is the
You are asking, if it is a case of any arbitrariness is a different thing, but policy decision, this court has restricts a lot of restrictions. This court, the power is very limited.
Lordship, can it be Lordship, the service which I have been rendered for the company, they can take decision discriminately for non-paying the lump sum.
No, why did you leave?
I have given
Did
resignation.
this happen before you left or after you left?
That is after. That is after my leave.
You left on some 2006.
In 2007.
6.
Lord,
You left in 2006.
I have the
And the decision they came up with on 4/7/2007.
decision is taken is 4/7/2000.
Now that is
Seven.
why
I left on Lordship April 25, 2007.
they took it on 4/7.
4/7. After
So-
that only. Immediately after
So-
that only.
Then they were giving those people some benefits at that point of time. Then to keep a check. So this is
Not
the
only
policy
for-
decision. Now you are asking that I should be also now given that benefit out there.
Lordship, only the thing is that they have taken the decision not only to check it, because they have taken the decision and take the decision to normalize the pay scale with the upstream and downstream companies. From the previous, from the very first onward, they are thinking of that. But they take decision after my resignation. That is another matter. But
But
it is
the
not a quick
the reason take the decision.
that
You see-
may be the one reason.
You
Lord.
see, there are two aspects. One is you not getting it. That is one aspect. The other is it's a policy decision. What is the policy decision is to keep a check so that people they don't leave. So unless I set aside clause 7, you can't get it.
No. Right.
Now, how do I set aside clause 7? You have to show the arbitrariness, so that the policy decision is wrong. Yes, policy decision can be challenged. There might be some illegality, you can very well do so. But otherwise, it's very limited. In one judgment of mine, I was referring to one just of a beautiful judgment of House of Lords on the question of Al Jazeera. It's a very nice one.
Lordship may go to the affidavit in opposition filed by them in the
Hmm.
page number 4. That is also one of the reasons.
What?
That said, Lord Mary, Thus, as regard to paragraph number so and so in the read petition, I beg to state that the pay scale of the executive belonging to the grade C, C1, D, E, and F, that is I am in E, in the upstream nation oil companies to the exploration of companies, etc., where one stage lower than that of the executive of the equivalent grades serving in the downstream national oil companies, the refinery, etc. And as such, there has been continuous demand made by the executive of the aforesaid grade of the upstream oil company to upgrade their pay scale to make it at par with the downstream oil company. That is the continuous demand of the executive lordship.
Then
Then they have decided to give the differential lump sum amount. That is also one of the reasons, not only because of some of the.
but you left it. You
left it,
found it that you are not going to get it, and as such you have left it.
Lordship,
And now after leaving it, then you realize, oh, I left it in 2006 or
2007.
7. Then you will go to Kuwait, work out there. Then you realize, oh, I lost something. Why not file a writ petition after 4 years? Huh?
Lordship, that is not only the reason. Lordship,
Very judgment. Yeah. Right. The English judgment. You see how it is mentioned. This is a case of Laker Airways versus Department of Trade, reported in 1977, 2 All England Reports 182. In the United Kingdom, aviation policy is determined by ministers within the legal framework set out by the Parliament. Judges have nothing to do with either the policy making or carrying out the policy. Their function is to decide whether a minister has acted within the powers given to him by the statute or the common law. If he is declared by the court after due process of law to have acted outside his power, he must stop doing what he has done until such time as the Parliament gives him the power he wants. In a case such as this, I regard myself as a referee. I can blow my judicial whistle when the ball goes out of the play. But when the game restarts, I must neither take part in it nor tell the players how to play. This is what, and this has also been approved by the Supreme Court in another judgment. This is a House of Lords judgment. So here it is the policy, it's their policy decision that we want to keep these people. I'm coming in 5 minutes.
Oil companies to upgrade their pay scale to make it at par with the downstream oil company. This is the main reason, and maybe that are also one of the reasons the executive has left the company. That's why they have.
That is the reason.
That is not only the reason, Lordship. This is the.
No, they have taken that step because of that reason only. There's no other reason.
They have admitted in their affidavit there is an anomaly in pay scale. Anomaly in the pay scale. anomaly in the pay scale, Lordship, I have also paid
Then
this.
why didn't you fight at that point of file a requisition in 2006?
Lordship, I have resigned on 2007.
Understood? Why didn't you file a
I have
requisition?
I have given the representation. I have filed in 2010 that has been withdrawn with the liberty to challenge the clause 7. And that after that, that has been filed again on 2000.
No, no, understood. But why didn't you ask for the pay scale at that point of time? That you should be given a pay scale to that.
That was the
You
company-
resign. After resignation, you join Kuwait Oil Company. And then one fine day you come up and say that no, no, no. I have to get the same thing. Why am I not getting? Then somebody told you that look here, you can't unless you challenge clause 7. And then you withdraw with and file this.
this is the clause 7 has to be balanced. Otherwise, we don't have a case.
So why is clause 7 bad?
Because that has been given to all the employee except us, the
No,
person
no,
who
not
are
all the
resigned for that.
They are giving, there is a basic reason why they are giving. They want to keep a check. The people, they don't leave oil in. Oil India, na? Oil India.
Oil.
The basic reason why they have given is that these people, they don't leave. And these are the only those people who are either died or superannuated, or those people who are what you call have taken voluntary retirement. These persons, a person who have resigned.
If it would have been done earlier, Lordship, before my resignation, that I would not have been gone to the Kuwait Oil Company, Lordship. But that has been done later on.
And you left because you didn't get it.
Okay? But that is only my submission is that, Lordship, I am asking for the amount for the service which I have been rendered for the company. That is as because they have admitted in their affidavit saying that that is a pay scale anomaly. If that is a pay scale anomaly, I am also entitled for that because I have rendered service for that in that scale pay.
No, but their specific stand in the affidavit is yes, there may have been a fair, but people were leaving and keep a check on these people. We have done this.
That stand they have taken.
That is their specific stand.
That stand has taken.
You have to show me that that stand is arbitrary. Can you show that? If you can't show that, then the matter ends,
Some Lordship. But
isn't it, Mr. Ahmed? He has to show this court that that stand of yours to only confine the benefit only to these people and not to others, in view of your policy decision to keep a check in the people being leaving Oil India, a national company, for better benefits outside. That is arbitrary. Show me that. You have a case?
Lordship, I have the that much submission of it. So,
Well, let me dictate. I ऊपर को लिखित हुआ. Which communication you are assailing? Clause 7 of? Where is clause 7 of which one?
Lordship,
Oh, where is 4.7? This one, 4.7.
4-7, Lordship. That is an excessive prescriptive of the receipt.
And Mr. Ahmed, what is this document then? Office order of 27/6/2007. This is oil. We are not concerned with oil. No. This is ONGC. So there the clause is 8.
Lordship, that is their clause is 8. Our clause is 7. But we have taken prior to date the decision because it is in 4/7.
Hmm?
It has been taken by Oil India on 4/7, and the
And
ONGC
ONGC on 27/6.
here it is. Sorry.
Okay. The instant writ petition has been filed challenging clause 7 of the circular bearing number PERS/01/12-2699 dated 4/7/2007, whereby the benefits of the circular was not extended to the executive who separated from oil other than on account of superannuation, voluntary retirement, early retirement, death on or after 1/1/97. The case of the petitioner herein is that the petitioner joined the respondent Oil India Limited as an executive trainee in the year 1988, and he was absorbed by the Oil India Limited as a production engineer after successful completion of his training in the year 1989. Please take your seat. The petitioner thereupon earned his first promotion in the year 1993 to the post of senior production engineer. And then in the year 1997, he was promoted to the post of deputy superintendent engineer, bracket OGCPL, bracket close. Subsequent thereto, the petitioner was again promoted in the year 2000 to the post of superintendent engineer. And then in the year 2006, he was promoted to the post of deputy chief engineer, production. On 25/4/2007, the petitioner submitted his resignation and sought release from the services of the Oil India Limited with effect from 5th of June 2007. In the said resignation letter, and here, subsequent thereto, the petitioner joined another company by the name of Kuwait Oil Company. And at the time of filing the writ petition, the petitioner was serving in the Kuwait Oil Company as a senior petroleum engineer. After the resignation of the petitioner, which was made effective from 5th of June 2007, on 4/7/2007, the Board of Directors of Oil India took a decision to compensate such affected executives in grade C to F by payment of lump sum differential amount arrived at notionally fixing by basic pay bracket including special pay and stagnation pay bracket with effect from 1/1/97 to 31/12/2006 in the manner stipulated in the circular dated 4/7/2007. In the said circular dated 4/7/2007, it was clearly mentioned that the benefits of the said circular would be available to those executives who were in service, as well as those who separated from Oil India Limited, on account of superannuation, voluntary retirement, early retirement, death on or after 1/1/97, however, the benefit of the said circular was not extended in cases of separation on account of reasons other than those mentioned in clause 7. The petitioner, on coming to learn about the said circular, submitted a representation on 21/3/2010 to the Chairman and Managing Director of Oil India Limited while working with Kuwait Oil Company so that the benefits of the said circular dated 4/7/2007 can also be extended to the petitioner. It further reveals that the petitioner thereupon filed a writ petition before this court, which was registered and numbered as WPC number 2815/2010, which was, however, withdrawn with the liberty to challenge the decision as reflected in the communication dated 4/7/2007 by filing a fresh writ petition. It is under such circumstances that the present writ petition has been filed. It reveals from the records that on 29/7/2011, it reveals from the records that the instant writ petition was filed on 22/7/2011. And by an order dated 29/7/2011, a notice was issued. The notice was issued in the instant proceedings. The record reveals that the Oil India Limited had filed a joint affidavit in opposition on 13th of December 2011. In the said affidavit in opposition, it was mentioned that the petitioner had tendered his resignation from the services of Oil India Limited, citing personal reasons. The petitioner was released from service after closing hours or working hours on 5/6/2007, and the petitioner never informed the Oil India Limited that he was working in Kuwait Oil Company. It was further mentioned that the pay scales of the executives belonging to grade C, C1, D, E, and F in the upstream national oil company, the exploration companies, etc., were one stage lower than the executives of equivalent grades serving in downstream national oil companies, the refineries, etc. And as such, there has been a continuous demand made by the executives of the aforesaid grades of the upstream oil companies to upgrade their pay scales and make it at par with the downstream oil companies. A large number of executives belonging to the aforesaid grades, especially from the core discipline, left the Oil India Limited to join private companies for getting higher scale salary and benefits, which had adversely affected the operation and smooth functioning of the upstream national oil companies. It has been mentioned that during the period from 2006 and 7, as many as 61 executives of Oil India Limited have left the company. Further to that, it was also mentioned that the issue of difference in pay scale was considered to be one of the primary reasons for such large-scale departure, and as such, the upstream national oil companies, including Oil India Limited, decided to address the issue of difference of pay scale, as stated above, in a pay scale, and compensate to the extent possible by making payment of lump sum differential amount. It is under such circumstances that a circular dated 4/7/2007 was introduced regarding payment of compensation towards pay scale anomaly in respect of executives in grade C to F whereby the Board of Directors of Oil India Limited had approved to compensate such affected eligible executives in grades C to F by making payment of lump sum differential amount arrived at notionally, fixing the basic pay bracket, including special pay and stagnation pay bracket close, with effect from 1/1/1997 to 31/12/2006. It was also stated that the benefits of the said circular would be extended to those executives who had separated from the company on account of superannuation, voluntary retirement, and early retirement on or after 1/1/97 whenever admissible, as employability of such separated executives in lucrative job was very less. It was further mentioned that similar benefits were extended to the executives who expired during the period from 1/1/97 to 31/12/2006 on compassionate ground. However, it was clearly stated that such benefit would not be admissible in case of separation on account of reasons other than those mentioned above. Further to that, it has been also categorically mentioned in the said affidavit that the number of resignations in the Oil India Limited came down to 15 and 16 in 2008 and 9 respectively in view of the said policy. It was further mentioned that the said decision so taken was not adopted on the basis of any government guidelines or orders, but it was taken, but it was an industry decision taken by oil exploration companies not to pay differential lump sum amount to executive who had separated from the company by way of resignation. In that regard, the decision, the circular of oil and natural gas organization, oil and natural gas commission, Oil and Natural Gas Corporation Limited, dated 27 circular of Oil and Natural Gas Corporation Limited, dated 27/6/2007, wherein a similar clause 8, wherein at clause 8 of the said circular, the benefit so given was restricted only to those executives who separated from ONGC on account of superannuation, voluntary retirement, premature retirement, death, on or after 1/1/97 have been granted. To the said affidavit in opposition, an affidavit in reply has also been filed by the petitioner on 14th of August 2018. From a perusal of the materials on record, and upon hearing the learned counsels for the parties, the issue which arises as to whether the respondent Oil India Limited had acted arbitrarily in excluding those personnel executives as the issue which arises for consideration is as to whether the policy decision of the Oil India Limited as contained in the circular dated 4/7/2007, whereby the benefits of the circular was not extended to those persons who separated on account of resignation is arbitrary and unreasonable. This court at this stage finds it relevant to take note of the scope of judicial review in respect to a policy decision of an authority. Reference in that regard, this court finds it relevant at this stage to make a reference to the judgment of the observation, the opinion of Lord Justice Lawton in the case of Laker Airways Limited versus Department of Trade, reported in 1977 to All England Reports 182, wherein, while considering the parameters of judicial review in matters involving policy decision of the executive, it was observed as under that judgment paragraph 41 no Puranic Bijoy Bora WPC number 475470/2021 paragraph. The Supreme Court had also, in various judgments, dealt with the power of judicial review in respect of the policy decisions. This court finds it relevant to take note of the judgment of the Supreme Court in the case of Sugar Works Limited versus Delhi Administration and others, reported in 2001 PSSC 635, and more particularly to paragraph 18, which categorically mandate that it is only in the case of arbitrariness, irrationality, perversity, and malafide that the policy can be rendered unconstitutional. The said paragraph being relevant is quoted hereunder. In the backdrop of the above, let this court therefore take into account as to whether clause 7 of the circular dated 4/7/2007, whereby the benefits of the circular have been not extended to those persons who have tendered resignation, requires to be interfered with. At this stage, this court also finds it relevant to take note of that the petitioner submitted his resignation on 25/4/2007, and with effect from 5/6/2007, the petitioner had already, the dual relationship between the petitioner and Oil India Limited had ceased to exist. It is only pursuant thereto on 4/7/2007, the policy decision was taken to grant benefits. To those persons, to those executives who were working, as well as those executives who separated from Oil India Limited on account of superannuation, voluntary retirement, early retirement, death on or after 1/9/2007. The said policy decision, as contained in the circular dated 4/7/2007, clearly stipulates that the said benefits under the circular dated 4/7/2007 would not be admissible in cases of separation on account of reasons other than those mentioned in clause 7. The affidavit in perusal of the affidavit in opposition, the details of which have been already referred to in the previous segments of the instant judgment, states the reasons why the policy decision was taken in order to put a check on the executives leaving the core discipline on the executives belonging to the grades, especially from the core discipline of Oil India Limited, to join private companies for getting higher salary, which had adversely affected the operation and the smooth functioning of the upstream national oil companies like Oil India Limited. The said policy under such circumstances, in the opinion of this court, now, it is also further mentioned that the reason why the benefits of the circular has been granted to those persons who had separated from the company on account of superannuation, voluntary retirement, early retirement on or after 1/1/97, whenever admissible, as employment of such separated executives in lucrative job was very less. It is the submission of the learned counsel, Mr. M.J. Ahmed. It is the submission of Mr. M.J. Ahmed, the learned senior counsel appearing on behalf of the Oil India Limited, that those persons who separate from Oil India Limited on account of superannuation, voluntary retirement, early retirement, or on account of death during the period from 1/1/1997 is a separate class altogether. And as such, the same cannot be equated with those persons like the petitioner who have resigned for getting higher salary in other private companies, in as much as those persons in as much as in respect to those persons, the employability of such separated executive in lucrative job is very less. This court is also of the opinion that the executives who have separated from Oil India Limited on account of the superannuation, voluntary retirement, early retirement on or after 1197 or had expired during the period from 1197 to 31/12/2006 cannot be equated with those persons who have separated by way of resignation to join private companies for higher pay scale. And as such, clause 7, by which the benefit has been excluded to those persons other than those persons who have superannuated voluntary retirement, who have separated from the Oil India Limited on account of superannuation, voluntary retirement, early retirement on or after 1197 and death during the period from 1197 to 31/12/2006 cannot be said to be arbitrary and unreasonable. Under such circumstances, this court is of the opinion that clause 7 of the circular dated 4/7/2007 cannot be interfered with. No, requires no interference from this court. In that view of the matter, as clause 7 of the circular dated 4/7/2007 cannot be interfered with, and the petitioner having separated from Oil India Limited prior to the circular dated 4/7/2007 coming into force, the petitioner is therefore not entitled to the benefits under the circular dated 4/7/2007. In that view of the matter, the instant writ petition, there is no merit in the instant writ petition, for which the writ petition stands dismissed. Hmm? 15 and 6. Now it is mentioned here na, in the affidavit. In the affidavit you have stated, I have not stated for anything else. The affidavit is here. You have said 15 and 6 in 2008 and 9.
Right.
Minor details, they look into it.
And number 7.
Yes, Mr. Bukun.
My Lord, a very limited prayer in the writ petition, my Lord. The petitioners numbering 58, my Lord. They were WCL, work contract labor, since 2000.
Who is paying for Oil India? Oil India is there. Is Oil India party?
Yes, my Lord. Respondent number 2 and 3.
Mr. Ahmed, you are not appearing in this matter. Who is appearing?
They would appear for respondent number 1 and 4.
Who is appearing? Okay, tell me, what is the case?
My Lord, the petitioners have been serving as WCL, work contract laborers,
Mm.
since 2000,
Mm.
more than 20 years, my Lord.
Mm.
And they have a charter of demand
Mm.
that for regulation of their service. So I take your lordship straight to Annexer C. my Lord.
No, here Oil India is not represented. You are a council Oil India. Who is the council of Oil India? Oil India has not appeared. Service has been made upon Oil India.
Respondent 2 and 3.
That's one number 2 and 3. Because they are the main persons.
Yes, my Lord.
Who is appearing? I can't see anything. Now, how are you saying Oil India Duliajan is the correct address? What is the registered office of Oil India? Huh? No, what is the registered office? Are you sure?
Respondent number 2, All India Limited, to the chairman and managing director, All India Limited, Noida, Uttar Pradesh.
Huh?
And number 3, President Chief Executive, All India Limited.
It is Noida, Uttar Pradesh. How can it be in the proper address like this? Noida is a small place. Service is deemed service on the basis of its correct address. Can't be like this. You appear for Oil India. Huh? You can't put it like this now. Oil India Duliajan, District Dibrugarh. Would it reach like this? Residence All India Duliajan, District Dibrugarh.
The well-known
What is the address? Hey, last. No, it's okay. He has it. What is the address to talk? What is that? Seven, 8, 0. This is okay. Then Oil India, Duliajan, District, Dibrugarh, Sam, pin 786602. Okay. Oil India is one, Indian Oil is different. No? Who else appears for Oil India? Huh? Essence of is we have to go to heaven. Huh? Ke Golita?
Angsuman Sharma, his son.
Hello. Anyways, let's see. But if the service is deemed to be complete, then again the problem will arise if I decide now in your favor. Because this is on deemed service, this has happened.
Miller, I will inform Mr. A. Sharma.
And A. Sharma, whether he has been asked or not, can you take instructions on this matter?
Yes, sir.
You take it.
Yes, I can.
You also appear, no?
After 3 weeks,
Hmm?
after 3 weeks,
Not
Your
3 weeks. 2011 matter. 12 years have gone by.
after 2 weeks, to be convenient for us, I send all the instructions.
Instruction is what? Only there has to be somebody represented out there.
Yes, yes.
What are you asking, Mr. Pukon? You are asking for regularization.
Regulation of service, Miller.
How is it possible?
Fulfillment of charter of demands, Miller.
How is it possible to regularize this court directing?
After this Uma Devi case, Miller.
That's a very difficult thing.
But that charter of demand, Miller.
What is the charter of demand?
Annexure C.
Annexure?
Annexure C is 29.
Regularization of services of contractors as per the seniority basis within 2 years.
And that provision
The
fund
deducted
aspect,
fund of the contract work be deposited in the PF to be included in the oil scheme. Revision of pay. Now what has happened? Then
Miller, since Miller, these demands have not been made, Miller. So Miller, this decision has been required.
that has not oil replied at all.
Not replied at all.
That becomes a problem, no?
No response, Miller. Only the affidavit has been filed by the respondent number 1 and 4.
What they say about the charter of demand, annexure A. Reference to your letter dated on the so and so. By this office has received another letter dated 9. This is the charter of demand.
Miller C.
This is what? 28/12/2009. What is that? 14/12. Okay, then in closing, there with a copy of the Iman of the newly and so and so. Further, so and so on Iman. In the instant petition, it is observed that under the same union and same affiliation as so and so, the two. Moreover, it is told that regarding the formation of committee of the strength, the light of it is difficult to take consideration in the matter of present status. It request to clarify with relevant to position.
Earlier, there were 2 factions, Miller, and thereafter, Miller, since 2011, Miller.
You can
Only
like
one
to
faction.
inform you
Headed by the
has been done to your stated demand. Like to inform you to inform either of the group that will be appeared. We have started the process to form one single united. Who are you?
Miller,
Oil
All India Workers Association, President and Secretary, respondent number, petition number 1 and 2.
Is this All India or Workers Association recognized?
Yes, my lord.
Where is it?
My lord, that annexure A and B, it will clarify the position.
What is this?
Page 27 and 28.
No, these are letters written by you. Is it being recognized by that?
The
By
register-
All India? Because here it is being stated by, there's another one, All India Trade Union Congress. There is another one,
It
as
was
All India
parent-
Trade Union Congress.
It was the parent organization, my lord, All India Trade Union Congress.
Hmm.
And Assam, State-
AITUC.
my lord, Assam State Committee is there, and these.
And you are who? You are
All India
Robin
Workers
Hazarika.
Association under AITUC.
Now, what is your association's name?
All India Workers Association, page 27, my lord.
Now, are you All India Workers Association? Is it affiliated with AIUTC?
Yes.
Huh?
Yes, my lord. So, my lord, the kindly see page 27, my lord. All India Trade Union Congress, Assam State Committee.
Does not, no, here it has been given All India Annexure B. Page 41, running page of the affidavit, page 9. Assam State Committee of AITC does not recognize either of the groups headed by P. Hazarika and Gunin Phukon respectively. We have started a process to form one single united committee of our affiliate Oil India Workers Association. Registration within a short period. Meanwhile, the discussion on the demand charter may kindly be kept pending for some days. We will communicate you in details. Then P. Hazarika writes here, Oil India Program, Ministry of Labor. I refer to this man to say, from the letter of the human so and so clearly indicates that a union having registration number so and so, you have no locus to function as well as participation in the statutory form at present. Existence of a union in the present status appears to be not in order, accountable and acceptable.
My lord,
Yeah.
kindly see the date, my lord, 30th March 2010.
Yes,
And the annexures of my writ petition, my lord,
these are 2009.
2009 and 10, my lord.
Yes.
Those annexed by the respondent number 1 and 4.
Then
Now my writ petition, my lord, annexure A, B,
no, you are asking for the Charter of Demands that is 14/12/2009.
my lord.
This is not a recognized your union.
But, my lord, that
Why should we recognize you?
annexure A and B, my lord.
This is not by a recognized union. This is not recognized. You are asking for a Charter of Demand. This is not recognized. Let it be done by proper persons. Mr. Phukon, you see, whenever there is a union problem, various unions springs up.
Actions are there, my lord.
And the moment I pass an order here, it will be giving a sanctity to your union or your set. Wouldn't it be?
My lord.
Then, if it is not recognized, why should we?
You know, only one aspect, my lord, I am be allowed to point out.
Hmm.
The affidavit, my lord, by the respondents,
Hmm.
they have annexed the letters
Hmm.
of February, March of 2010.
Hmm.
Same person, my lord, that the first one by Munin Mahanta.
Hmm.
He is the General Secretary of Assam State Committee of AITUC, All India Trade.
Let us read paragraph 8 of the affidavit. You have a copy, Mr. Counsel?
Yes, yes.
You have got it?
May I read?
We'll show your representation. And where are you? You, Mr. Borua, you are there. Labor,
Assistant Labor Commission.
No, state is not a party here.
what? Step 1 and 4 is you.
Ministry of Petroleum. This is
Number 4 is you, Assistant Labor Commissioner.
Yes. In fact, this was not reflecting, so we are unaware about this matter.
Okay, both of you share that one file now.
My
Yes,
lord, paragraph 8.
yes, really.
That with regard to the statements made in paragraph 7 of the writ petition, the deponent begged to state that it came to the notice of the Assistant Labor Commissioner Central Dibrugarh, respondent 4, When a copy of the letter dated 28/12/2009 was received from All India Workers Association with registered number 730, affiliated to AITUC, intimating Sri Gopal Mili as president and Sri Gunin Phukan as general secretary with name of other office bearers. That same union, namely All India Workers Association with same registered number 730 and same affiliation for the same period, having two presidents, namely Sri Praveen Hazarika, petitioner number 1, and Sri Gopal Mili, and two general secretary, namely Sri Jugan Haloi, petitioner number 2, and Sri Gunin Phukan, and secretary Sri K. Sarkar, which appears faction in the union and same not in order. Hence, the deponent by the letter number so and so dated 7/1/2010. It is important. 7 January 2010. Asked the petitioner 1 and 2 to clarify the position with relevant documents for entertaining petitioner's charter of demand dated 14 December 2009. Further, the deponent begs to submit that the General Secretary All India Trade Union Congress Assam State Committee Guwahati has intimated to the next page. Assistant Labour Commissioner Central Distributor Respondent number 4 by the letter dated so and so dated 2 February 2010 that Sri Praveen Hazarika, the petitioner number 1, and Sri Jugan Haloi, petitioner number 2, have not been recognized by them as the President General Secretary of All India Workers Association. Hence, considering the above fact and circumstances, the Assistant Labour Commissioner Central Distributor has intimated to the petitioner number 1 and 2 that they have no locus standi to function as well as to participate in the statutory forum in present form, and the existence of the association led by the petitioner number 1 and 2 in the present status appears not to be in order, accountable, and acceptable. That their self-declaration as President and General Secretary without substantiating any supporting document to prove their existence is not acceptable. Copy of the letter dated, these letters are important dates, 7 January, 2 February, and 30th March of 2010 are annexed here, annex A, B, and C. Now my read petition, Miller.
No, Mr. Phukan, the thing is like this. You want regularization,
Miller.
which can't be done. You want the compliance to a charter of 14/12/2009. That charter of demand is given by an organization which is in doubt. It is not given by the other petitioners. It is given by an organization of a president and secretary which is in doubt.
Miller.
Then why should this court at all entertain this petition? How can this court say about the charter of demands when you are not a person who is recognized? I would have understood if all the other petitioners have given, then I could have very well said it. This court could have very well said that, okay, let their charter of demand be taken into consideration. But that organization is in doubt as to whether the petitioner number 1 and 2 can represent Oil India who had issued this charter of demand. The charter of demand is by two persons. You see, for these two persons only, petitioner number 1 and 2.
President and General Secretary. Miller, I'm focusing only on one aspect, Miller. Miller, the affidavit filed by the Assistant Labour Commissioner, Miller, it is regarding pre-April 2010 communications by the Secretary of the Assam State
No,
Unit.
but your
That's-
charter of demand is on 14/12/2009. That is your prayer. Then these documents are of 2010.
But my annexure A and B is clear, Miller.
What about annexure A and B? We are not concerned with annexure A and B. These are 2/4/2010. This is given by some Munin Mohanto.
And the
You are
earlier
not
comment-
asking for all these things. We are not asking for these two aspects. We are not concerned with that. There is no prayer in respect of annexure A and B. We are concerned with annexure C. Annexure C is a document of 14/12/2009 whereby there is a doubt being expressed by your parent organization that you are not the person who are actually holding the fault for this All India Workers.
Miller, in the affidavit, their stand was
It's a
Prior-
civil suit between both of you. You won the sanctity out here. There was a matter pertaining to, what is that matter? ADDA, Assam Drug Dealers Association. I was the lawyer. So I filed a writ petition challenging a particular government's action. So there was the other person who was also representing ADDA, another. They come and, no, we also won, but don't recognize him. It is the same state of affairs.
The trade union activities, there are several sections. But the affidavit is not clear about the subsequent development. They have been focusing only about the pre-2010, pre-April 2010 development, and not about the post-April 2010 development.
But I
Same
can't do it.
person.
Understood, but that is there. But the charter of demand,
It was of December 2009, I admit, Mr.
that is the problem.
I leave it to you. Lord. But their affidavit is not clear. They have focused about the
Mr. Pukon, you withdraw this petition. I'm saying why. The moment I say, because there are other petitioners, na?
Yeah.
If I dismiss this, their rights would be affected, if any. Because they are not a part. I have to hold that the power of regularization is not there. The moment I give that, the entire chance of regularization, if it is any or nothing, will finish.
go to now.
Second is, if I dismiss on this ground, your people, if there is any fight later on between both of the factions, this will have a hamper upon it. So I think you take recourse. You say that you take a recourse before any other appropriate authority. I think that would be a better option. Because the moment I dismiss it, it may have a far-reaching consequences on the other people. Because I can't give a direction for consideration of the charter of demands when the authorities, your parent organization, AIOTC, categorically holds that you are not, that you are noble. It will have a lot of consequences. I am thinking about the petitioner, rest of the petitioner, after 2, 3 onwards, they would be affected.
Who has already expired?
The 2 is okay, but one is there, but the rest of the petitioners will be affected. I think the better of you take recourse.
I'll beg to withdraw me, Lord, with liberty.
With liberty to approach the appropriate form.
Yeah.
I think that is a better option. Or, the learned counsel for the petitioner submits that taking into account the stand taken by the state, respond number 4, the petitioner would not like to press the instant writ petition. However, would like to approach the appropriate forum for redressal of their grievances. Taking into account the above, the instant petition stands closed on withdrawal. However, liberty is given to the petitioners to approach the appropriate forum for redressal of their grievances.
Most of
Yes, 1, 2, and 3. You give your name, huh?
Yes, yes,
Both of your name.
yes. Who I am appearing, madam. Madam, the council, madam, H. Burua, he expired. madam.
First, let us not go into. Other side is not represented.
Yes,
Dismissed for default. None appears on behalf of the petitioner on call, although the matter has been called on the for the second time. Matter accordingly stands dismissed for non-prosecution. It appears that the petitioners are not interested in pursuing with the instant proceed, and accordingly the petition stands dismissed for non-prosecution.
my name may be.
No, nowadays I don't put anybody's name, so you give your slip.
Okay.
You are there? 1, 2, and 3. Yes,
number
Mr.
8,
Biswas. Your matter, item number 8.
orders.
Yes,
Well, the matter relates to the claim by the Bazaar Committee to have a additional land for their market. They
Mr.
have approached the
Datta,
Deputy Commissioner,
affidavit?
they have not filed.
We have not filed it.
And a private respondent, he in spite of the notice did not turn up. He is the main person who has started constructing, in spite of the fact that we have filed this case before the court. He want to occupy the land, but ignoring the benefit of the public. And
You have allotted the land to the,
No, we have
not
not
allotted.
received instruction, Lordship. As per his report, annexers, the private respondent has already occupied this land.
He is a landholder, he is having.
Huh?
He is a landholder, he is having own patta land. In spite of that, he wants the additional.
you
fertilizer.
also have the land. You also have 2 bighas of land.
No, that is Bazaar Committee, my lord.
Then,
We are Bazaar Committee, my lord.
so
We
you
want-
want another 3 katha, 4 katha.
Because it is not sufficient for the for Bazaar matter. That's why we have approached the authority, circle officer, deputy commissioner, that let the adjacent land be given to us.
So what is your stand?
We have to take instruction, Lordship.
Understood, but why? This matter has been pending out here. From 15/3/2023, you don't have instruction. It's sad.
Circle officer also remains
Mr.
silent.
Datta, what is wrong?
Lordship,
Why there is no instruction?
perhaps earlier council have not issued
Perhaps.
issued letter. Lordship.
Perhaps the matter didn't come before this court earlier.
After 10 days, Lordship, I will take instruction.
When I was taking the pension matters, we used to get all the instructions very soon.
Yes.
These bench 4 matters, there's no instruction for years. The other matter also 2022, no instructions. Nothing is happening.
My lord, we have filed on IA for that, my lord. That let them be take any action to restrain the private respondent not to extend the construction. He is starting Pakka construction. That will be another problem for us if you get the land.
No, if it is a land does not belong to the private persons, where is the concern of construction?
Police is silent.
That will be
circular is
demolished.
silent, nobody is taking any action.
You get your instructions, we'll have it on next week, on Monday.
Lordship,
Get your instructions
Look.
Monday.
Lordship.
What have you done to the application?
Till then, my prayer is that
Mr. Biswas,
they should not
Nothing.
go on construction.
today is Tuesday.
Yes.
Till next Monday, if they have put another 2 floors out there also, it may,
That's
you
true,
take it. Don't worry. Don't worry. Mr. S. Datta, the Learned Counsel, appearing on behalf of the Revenue Department, shall apprise this court on 24/7/2023 as to what steps have been taken pursuant to the application filed by the petitioner seeking allotment of the land in question. Full stop. Is the Deputy Commissioner a party?
Yes,
Yes,
Lordship.
yes.
Yeah. Mr. S. Burwa, the Learned Counsel, appearing on behalf of the Deputy Commissioner, which?
Of
Kamrup.
Kamrup. And Circle Officer is there?
Yes, he is also party.
The S. Burwa, the Learned Counsel, appearing on behalf of the Deputy Commissioner Kamrup as well as the Circle Officer?
Of
Somalia Revenue Circle.
Huh?
Somalia.
Somalia Revenue Circle shall also apprise this court on the next date as to what is the status of the construction, as to whether apprise this court as to whether there is any construction being carried out in
Minus number 6.
in the land in question.
Diploma.
Please recording. Get your instruction.
Lordship,
Ready for-
I'll-
Yeah.
Item 9.
Mr. Talukdar, your matter is a very complicated one.
It's simple for your lordship, my lord.
Huh? Compulsory retirement. You are not getting your pension.
My lord.
Why? Compulsory retirement, we understand that if it is a compulsory retirement, he gets everything else. Why you are not giving him pension?
My lord, subsequent to my retirement and the disciplinary proceedings, my lord, which was initiated, that was continued. And pursuant to that, my lord, I have been found guilty. Now, subsequent thereto, my lord, the impugned order has been passed, withholding my entire pension. Now, thereafter, my lord,
How?
under Rule 21, they say under, but I will show, my lord, that is,
How can it be done? Has it been done by the governor?
no, that cannot be done. That is
If
my
it is
case.
not done by the governor, how
Yes,
can you have?
that is my
Oh, Mr. Poor, is that the same matter?
No, you also.
Oh, there was another matter.
This is
What happened to that matter? That was, I think, Miss D. Borgohain was appearing in the other
Yes.
matter. Ah. It requires an order of the governor. Part 2 matter is it? Mr. Bora, part 2 matter with get the file. Put it out there. Part 2 lawyers. At 2. Part 2. Yes. How are you doing it?
68, no?
You have been compulsorily retired.
Yes.
Then they have initiated that they continued with the disciplinary proceedings.
Correct. My lord, before my compulsory retirement, they had already initiated.
Ah.
That is a DPML. Now, midway through, they invoked 56B and my lord, I was compulsorily retired.
Oh,
Thereafter, my lord, the DP was continued.
okay. Then
Then, my lord, the inquiry report said that I am guilty. That was accepted. And my lord, the punishment of withholding of the entire pension, my lord, that was passed. Impugned order was passed by the disciplinary authority.
okay. Then
And,
but
thereafter,
the disciplinary authority can't do that.
cannot do that, my lord.
That is that has to be done by the governor.
By the governor. Cannot do that.
Oh.
And there is a division bench judgment, your lordship had, my lord, indicated,
Hmm.
1983 or 84, I have that with me.
Hmm.
My lord, it says, having regard to Rule 21, that was, my lord, discussed, it was construed, saying that a show cause notice, my lord, is necessary. My lord, there is no automatic continuation.
Oh, it is. That was prior to the amendment. Prior to the amendment, you had to. That is why the amendment was brought in. You could not have automatically continued earlier.
Yes.
But because of the judgment, there was an
explanation is
amendment.
given here, man.
Ah,
Yes.
that is that amendment which is up.
Yes.
So it has to be continued thereupon.
Yes.
But another thing is, how can the punishment of withholding the pension be taken under what provision? That will be done under 21.
Yes, sir. And it was initiated under the 1964 rules, my lord, discipline and appeal rules.
Hmm.
And under that rule, my lord, no punishment regarding withholding of the entire pension is prescribed.
64, it does not.
Does not
But it will continue in view of that proviso.
provide.
That was an amendment which was brought by that proviso, it will continue. Then thereafter, but one thing, Mr. Taluga, this court is finding one difficulty out here in these type of matters that isn't it required to put somebody to notice? Yes, it will be continued. The power is given. The governor has the power, but the governor can only exercise the power if it is a case of moral turpitude and what are these which have been mentioned.
Yes, yes.
Merely a guilty would not be
Yes.
21.
Yes.
It requires something more than that.
More than that. Grave misconduct.
Grave misconduct.
Yes. And the disciplinary authority has to arrive there,
Ah.
that it is a grave misconduct. Then only, my lord, it will occur.
Then only it can only happen.
Yes.
Merely in misconduct, it can't be.
Cannot be. And by the time, my lord, I have been acquitted by this honorable court, the conviction has been set aside. And it is an honorable acquittal. This honorable court says there is no iota of evidence in respect of my involvement. So that part is also there.
No, but that is okay. But the problem arises with that they have come to a finding that we have not challenged that, no?
Correct. That is not under question.
But your limited point is on 21 only,
21, my lord, 21,
that the governor has not done it.
not done. It is without jurisdiction, my lord.
That order has to be passed by the governor.
My lord, correct.
Yes, Mr. Kaur.
Your Lordship, the impugned order, Your Lordship, item number, page number 57, Your Lordship.
I'm coming in 5 minutes. Wait, and yeah, yes. Where?
Page number 57.
Ah.
Your Lordship, the order is here, Your Lordship. In the name of
Order
governor,
for
it was
withdrawal.
issued. Your Lordship. In the
Governor
last
is
paragraph,
pleased to withdraw
accordingly, the governor of Assam is pleased to order.
for withholding obligation. So this is done by the governor.
Yes.
So this is the governor's order.
Prior to that, my lord, they have already, my lord, in fact, arrived at a decision. Page 56, my lord. And before that, my lord, so cause it's not issued to me.
Huh?
That there is a continuation.
Why is it there? So cause issue. We'll come at 2.
Well.
You have records?
The other one, if your lordship, my lord, sees the impugned order, there is no findings, my lord, that he is guilty of grave misconduct. There is a findings, my lord, in respect of the, my lord, inquiry report that he has misappropriated, but it does not spell out, my lord, that being, my lord, guilty of grave misconduct, my lord, the decision has been taken to withhold, my lord, the enterprise. So in that view of the matter, my lord, part of the, my lord, pension can be, my lord, withdrawn, or the recovery in respect of the alleged misappropriation, my lord, can be made. So that is my respectful submission.
A misappropriation of government money isn't it the amount of misconduct? Grave misconduct.
But in terms of the rule, my lord, my lord, he retired in 94. Now, my lord, 30 years, my lord, did not get any pension. And there is no, my lord, earlier, my lord, any such instances, my lord. And others, my lord, all have been, my lord, in fact, my lord, exonerated. They have all, there were other, my lord, co-accused. They have been exonerated. They have receiving pension, my lord. Only he has been made a scapegoat, my lord, in the entire process. And the criminal case, my lord, the honorable court says there is absolutely no iota of evidence. My lord, it's an honorable acquittal. It's not on, my lord, benefit of doubt. If your lordship comes to the order of the, my lord, this honorable court in the criminal appeal, I'll draw your lordship's attention to the relevant part. Criminal case, my lord, directly I take your lordship's, my lord, to the relevant part. It is at page, my lord, 67, para, my lord, 33. What emerges from the above discussion is that the prosecution has, in the present case, miserably failed to adduce evidence to show as to who had maintained the cash in question, far less proving that at the time of handing over the charge by the appellant, that is, my lord, the petitioner, had not given a sum of rupees so-and-so to the officer who had relieved him. This is the same amount, my lord, finding place in the, my lord, order, impugned order. So there was an allegation, my lord, that I am in collusion with the, my lord, cashier. Now, in my reply, I have stated all these things, my lord, and thereby requested, my lord, to drop the charge because the charge is, my lord, misdirected against me. That was my lord, stand in my reply. But since, my lord, I have not challenged the inquiry report, that stands as on date, my lord. My submission would be, my lord, that on the facts, my lord, it would be justified that the amount which is alleged to have been misappropriated, that may be recovered, my lord, in terms of Rule 21. Rule 21 empowers the government, my lord, to recover the loss, my lord, which is caused to the government. At least, my lord, that may be done.
Yes, Mr. Kumar.
Your Lordship, my learned friend has referred to the judgment given in the criminal appeal, Your Lordship. On the paragraph 33 of the judgment, Your Lordship, It says that the prosecution failed to prove, Your Lordship. That means prosecution has to prove beyond reasonable doubt. So, Your Lordship, departmental proceeding and so far as the criminal trial, two distinct.
Understood. That is okay.
Okay.
Not on that. The only concern is the total amount was 6,28,000.
6,28,450. Your Lordship, the
So the petitioner herein was compulsorily retired when?
My lord, he was compulsorily retired in that order, my lord. I have annexed,
at page number 46, Your Lordship.
my lord.
It's not punishment, Your Lordship.
No, it's okay.
Not a punishment, my lord. It is 56B. But, my lord, it is in public interest.
No, it's okay. 1994.
Yes, my lord.
Then
1990.
when was the impugn order passed?
It was passed
97.
97.
So from then onwards, he's not getting his pension.
No,
Because Your Lordship, the as a thorough departmental proceeding was,
No, understood. It's okay.
He
But we are on the
participated.
proportional.
Your Lordship.
We are not on the
kindly see
other thing.
Page number 56.
Because
Your
his
Lordship.
submission is only on the question of proportionally.
Yes.
Now, this petition was filed in the year 2015 when he
Yes.
was 71.
Otherwise, also in the before issuing that
Today
impugn
is
order,
8 years. Now he's 79.
it's okay, Your Lordship, but before passing this impugn order, the so-called notice was issued to him, and he also submitted his reply. Everything was done, Your Lordship.
Before
All
passing
reasonable
this
opportunity
impugn
was given.
order, so-called notice was issued.
Yes, Your Lordship. Kindly see the page number 56, Your Lordship, of the petition. Your Lordship. May I read? In inviting a reference on the subject cited above, I am directed to say that the government has decided to withhold or withdraw your entire pension, including gratuity, etc., for misappropriation of government
And
money.
against that, he has submitted his reply.
And you are requested to furnish your reply of the representation, if any, within 15 days from the date of receipt of this letter. He was given the opportunity of all opportunity was given to him, and he duly participated. Even before issuance of the impugn order. Your Lordship. And moreover, that
And what did you do? Did you assail the inquiry report?
that
Then also.
that was not done. It was
Then also you didn't do.
mistake on his part.
Then how do I help you?
Yes, yes, correct, my lord. I have entered into, my lord, personally in 2015, my lord. But earlier, my lord, what he did, my lord, that was inadvertence on his part. That was a mistake, my lord, committed.
If you have
Inquiry report ought to have been challenged, my lord.
understood, not only that,
Yes.
when this was being given, what did you do when page 56 was given?
Yes.
What did you do? Didn't reply.
Yes, but it appears, my lord, he had given a reply.
Where?
It appears from the order itself.
No,
page
it doesn't say anything about reply.
57. Page 57, it says.
Yes, where is it?
The
Reply.
first line, my lord, first line.
first line. Your Lordship.
Read and peruse the reply to the show cause notice, which also collected documents submitted by so and so, retired so and so, along with the inquiry. This case was criminal case was filed against how many people?
There were, my lord,
And what was the petitioner? He was the cashier.
no, my lord,
Is
at
it-
the relevant point of time, he was
Is
the
that-
assistant director, my lord.
Assistant Director. Your
Assistant
Lordship.
director.
Yes, the Assistant Director.
Charge, my lord, if your lordship comes to the charge, the charge sheet your lordship will find at page 34, my lord.
Where's the inquiry report?
Enquiry report, my lord, is not part of the record.
You have the records?
No, Your Lordship. But
Why, means, Mr. Talukdar, very hopelessly done.
My lord, I have made a statement. In fact, that could
Your
not be,
statements are not going to help you, na?
it could not be, my lord, Suppose-
You are not leaving any leeway
correct,
for
correct.
this court
I
to
understand,
exercise
Lord, absolutely
jurisdiction.
correct.
No way this
Yes,
court
yes.
is going to help.
Your lordship, then, sir,
If
right, I
this
understand.
court to bring something that the
Correct.
other people were there, they were now been not being
Correct.
done. You are saying about scapegoat. Scapegoat will be if somebody, then only also if this court, how can this court, why are you challenging this? Why are you challenging the order at page 57? Why? On a proportionality.
No,
On what ground are you
ground
challenging?
is that his appeal was allowed. He has given the acquittal. That is the ground.
No, not that. Is that the ground?
Well, in fact, that is one of the grounds, but I'm not pressing on that.
That obviously
now I'm
Mr.
on the
Talukder
proportionality,
won't
man.
press.
Yes. I'm on the proportionality. ma'am.
Proportion.
That since my
But
lord,
if
under
proportionality, how can this court look into it? Unless you show something that it is too drastic. How do I see? The inquiry report is not there. There is a case of misappropriation of 628.
Lordship, in the year 92, 93, it was a huge amount. Your lord.
Mm. '97, 628 is, this happened in 92,
Yes, your
something
lord.
like 60 lakhs.
Yes, your lord. That's right.
No manner. Can't help you. Because this document at page 56, what that creates the problem, na?
well,
If that document was not there, I was thinking I could have helped you just giving something. But
Well.
with that document there, we can't help.
Well.
Because I am always of an opinion that if you initiate the proceedings during the tenure, and in the meantime a person retired, you can't fall back upon the amount, the punishment which is given there.
Yes.
The punishment can only happen as per the rules of 21 or
21,
20 or 21. Then my opinion is there is a requirement of a notice so that he can also have a say on this, which have also been given
no,
here.
no, in that case, I can argue. ma'am.
Yes, please argue.
My lord, that notice, my lord, has to be, my lord, this is also division bench judgment. Notice has to be there. Why any action should not be taken under Rule 21? It is not there. Because here your lordship will see, they have
That division bench judgment is of 81.
83, but the
But
ratio.
no. That was, you see, that is for continuation. That is for continuation. See, this amendment was brought in 1980.
80, my lord, 9.
This was
89.
brought because of that judgment.
Yes, correct. That for that judgment. Yes. So the ratio of the judgment will not apply. Now it will be automatic continuation.
Mm.
But what the division bench say that the notice is in respect of, my lord, the action or proposed action under, my lord, the pension route.
In fact, Meghalaya, as I told you last time when the matter was there, Meghalaya although adopted the Assam pension rule, but they have not adopted this explanation.
Or this one. So that automatic continuation part still continues, my lord.
In fact, when I was a lawyer, I got somebody a pension on the basis of that. There was a managing director of a, was caught red-handed with some money, and disciplinary proceedings was continued after his retirement. But there was a note that proceedings
cause.
was not initiated with the concurrence with the governor. So on the basis there, because it required the concurrence of the governor. But now with this explanation, that is why the explanation comes because of that.
Correct.
Therefore, if you see it, if you have the red book, do you have the red book?
I have the book, this one, my lord,
Anyways, down below, if you see the insertion,
Yes,
the
yes.
explanation,
1989.
no, but notification number is 83, you see?
Yes, sir.
That explanation part has been inserted in 19 Gazette notification 89.
What is the notification number?
Number, my lord, is part Gazette, Assam Gazette, part 2A, dated 4/1/1989. Notification number FMP 1484/83. This is 89. For subsequent to the division bench judgment, not to be correct.
That is why.
My lord, on proportionality, my lord, can I
Yes.
assist your lordship 2-3 more days, my lord? I will try, my lord, to give something to assist your lordship so that lordship can at least is now 89 years, 79, 80 years old, my lord. So on that proportionality, lordship will consider. Otherwise, on merit, my lord, I don't have a case because I, in fact, my lord, advised him to challenge the inquiry report. He could not, my lord, punish me. He said that it has been misplaced. I have made a statement in the repetition of
Yes.
Inquiry report.
inquiry report.
You have the inquiry.
So you will have to communicate with the department, your lordship. At present, I am not holding the inquiry.
If your lordship finds that
But it
is
was
vague,
furnished to him,
is
page 11.
perverse,
Hmm?
then if your lordship finds that inquiry report, obviously, my lord, without challenge to it, my lord, the lordship cannot come to any conclusion. But at least, my lord, I pray lordship will go through the inquiry report.
No.
I
First
will-
and foremost, tell me one thing.
Hello.
Whether the inquiry report was furnished to you.
Yes, your lordship. Page number 11, he has given the statement.
I have
Huh?
given a
He has given the
statement
statement.
that has been misplaced. That was also a ground for me. I asked him, my lord.
Page
Page 11, your lordship.
of what? Of his
Of the
petition.
Yes.
Is a petition.
That is misplaced by him, my lord.
Regarding what?
Your
Inquiry
lordship,
report.
it is stated that though the inquiry report attributing guilt to the petitioner was supplied to him, the petitioner inadvertently has misplaced the same. So it was supplied. Punished to him.
Oh, that is stated that though the inquiry report attributing guilt to the petitioner was supplied, the petitioner inadvertently had misplaced. Let us see that the 94 order, because the order was passed in 97,
97.
Your lordship.
then why was the EI the 94?
My lord.
See, in exercise of the powers under 56,
B.
to retire and so and so, an appeal under section 15 against the order of the year passed by the governor of the Iman under 56B. No, in
But it
fact, that can't be so. Can't be. When was the inquiry report? What is the date of the inquiry report?
This is, my lord.
It couldn't have been. No. Mr. Taluga,
My lord.
I think you may have a case on that.
Yes.
You see, this statement
Yes.
has to be read with a compulsory retirement because you see the copy of the kindly come to page 11,
Para 11.
page 11 of the
11.
petition.
Yes.
Here it says compulsory retiring the petitioner is that before completion of the department of employee relation midway. It is further pertinent that after passing of the said order of the discipline initiated against them was concluded. It said that though the inquiry report attributing guilt to the petitioner was supplied to him, the petitioner had misplaced. But whether there was an opportunity given to you for replying or pointing out to the lacuna in the representation.
That will be form a ground matter.
That
In
may
fact,
be
the
a-
records would be necessary on that point. Ma'am.
Yeah.
Lordship will record it and he will place the record.
Yeah.
At least that will be a ground melon for your lordship giving a leave email.
Yeah, that is the only
Yes.
way out.
I'm applied. Ma'am.
After 79 years old, something has to be done.
So I have all sympathy with the petitioner. What
No,
laws which you-
why I'm otherwise I wouldn't have. Only one person. There were other people also.
Yes.
If
If no action has been taken by the department as against others, but only against him, that is the only reason why I am saying. Otherwise, I wouldn't have.
at present, their
So
instruction
anyway,
is not with
heard,
you.
yeah, I heard na lage, wo upar na leva. During the course of hearing, this court is of the opinion that the interest of justice would be met if the records pertaining to the disciplinary proceedings wherein the inquiry report and during the course of this court is of the opinion that the records of the inquiry proceeding, disciplinary proceedings, is required to be looked into. More so, as to look into as to whether the petitioner was given an opportunity to have a say as regards the inquiry report. Mr. K. Kaur, the learned additional advocate general appearing on behalf of the state, is directed to produce the inquiry, the records of the disciplinary proceedings on the next date. List the matter again on 7th of August or 8th of August.
It was yes. Oblige me. Oblige you. Your lordship, your lordship may keep it as part of your.
Not necessary. Partner, I don't have any partner. I don't keep partner.
It will help me.
Huh?
Oblige will help me.
No, it's okay. You will come back to me only. Didn't you see this matter have been rolling around, and after this matter
Oblige you.
during the course of extensive hearing. Number 10. Yes, Mr. Kaur.
Yes.
That the other one. The senior court.
Lordship, here in this case, Lordship, so far an additional affidavit was filed.
Well,
by the
additional
petitioner.
affidavit has been filed long
Yes,
back.
Lord,
My
yes,
learned
yes,
friend
Lordship,
is trying
yes,
to
Lordship.
sit.
I do admit,
Ah,
it, Lordship. Yes,
well, and
I
this
do
additional
admit.
affidavit
Yes.
has been filed,
no.
putting a query to both of us. It should
Yes,
have
yes,
come from him.
Lordship. I do admit it, Lordship. But at the same time, some new facts arises in this in that affidavit, Lordship.
No.
And therefore, Lordship, I need, Lordship, I'm preferring, Lordship. I need some time, Lordship. Just a few time, Lordship.
But this 200 rupees. It's a case of 200.
But I have
It
stated
is not,
nothing
not
new.
a
It's
matter
there.
of 200 rupees, Lordship. It is a matter of policy decision, Lordship.
No policy
matter.
decision. There's no policy decision here.
And my lord, I am only
Yes, yes,
annexing
it's a case
those
of-
documents which are already
So
on the
what is
record.
that? Your slap or cells? So what is slash?
Slash.
And they have adopted modified
Yes,
slash.
yes, Lordship.
Well, your lordship will hear me.
An opportunity is required, Lordship.
Your lordship will hear me.
File my response, Lordship, on this regard. Lordship. He
This is not
categorically
fair to me by the
categorically
my friend.
submitted some new facts, Lordship.
No.
Yes,
No.
some new facts.
No.
Some new facts.
No, I have not stated anything.
Don't worry, Mr. Kumar. It's out here in big bold letters. It has been shown as before the Bolwa only.
Yes,
It will come to me only.
No, Lordship,
No,
I have
Not
nothing.
before
Not
of the
today.
bench, my
We'll
lord.
have it when?
Lordship, next week, Lordship. Anything.
Next week. Next Tuesday. Next Tuesday.
My lord, I will be away again from 22nd to 25th. My lord.
Okay, 22nd to 25th. We'll have it on 27th.
Yes.
That's
List the matter again on 27th. Mr.
J.K. Goswami.
J.K. Goswami, the learned counsel, appearing on behalf of the SIDC. AIDC, seek for an accommodation to rebut to the affidavit in reply, additional affidavit filed by the petitioner. On the other hand, Mr. P.D. Kumar, the learned senior counsel, expresses great urgency in the matter.
And they will submit an advance
The
copy.
affidavit the reply affidavit, if any, be filed by 25th of July without fail.
Lordship.
List on according. List on.
Deployment.
20. Yes, part 2.
Part 2 hearing list civil bench 4. Item number 93 and 94.
On my idea, nasle nahi bhai. Enter. Yo. Mr. Kumar, you have matters, part 2.
I have just asked my junior to check.
$2014 or? My goodness. What are these matters? None appears for the petitioner, MK Chaudhary appears postponed, none appears for the petitioner. What is this matter about? Advertisement for the petitioner hearing is qualified ladies belonging to ST applied for distributorship under so and so. The scheme is exclusively reserved for ST community, but until one person, namely Nagpur, who does not report that they have been selected for distribution. The commissioner of capturing the illegal system. Okay, in selection of the third. Is there a stay? The commissioning of the offence is made subject to the outcome. Repeating of position. No. What is this website? No. Both the writ petitions. No. The facts involved in both the writ petitions being parameterial and the issue involved are common. Both the writ petitions are taken up for disposal by this common judgment and order. On 21st of February 2013, an advertisement was published in the vernacular Assamese Daily, Ohomia Protidin, which was followed by another corrigendum issued on 16th of March 2013 for appointment of distributorship under the Rajiv Gandhi Gramin LPG Vitrak bracket RGGLV bracket close scheme of the Indian Oil Corporation at Dwarkuchi under Tamalpur Block District Boxa, Assam for ST category only. Full stop. The petition is in WPC number 4649/2014 and WPC number 4667/2014, along with the private respondent. Parties submitted their applications. The candidates thereupon were asked to be present in the occasion of draw of lot for selection of the RGGLV to be held on 23/8/2013 at Satyanath Bora Hall, Digolipukuri East, Tayabullah Road near Cotton College Girls Hostel, Guwahati. In the said draw of lots, the private respondent, that is Topon Lohkar, was selected as the dealer / distributorship in RGGLV scheme for the location of Dwarkuchi in the district of Bakcha, which is reserved for ST category. The petitioners in both the writ petitions have alleged the selection of the private respondent, Topon Lohkar, on the ground that the private respondent do not belong to the ST. Mr. Borgodogi, you are there in this matter, this IOCL, no?
Maybe not this matter.
93, 94?
No.
Okay. The petitioner in both the petitions have assailed the selection of the private respondent Topon Lohkar on the ground that he does not belong to the ST state, does not belong to the ST category in the state of Assam. And it is on the basis thereof that both the petitions have been filed. It appears from the record.
I'm very sorry, my lord. Actually, there are cases that I'm very sorry.
It appears on record that
Let's just bring
the respondent number 2, 3, and 4, that is the Indian Oil Corporation, have filed their affidavit in opposition. In the said affidavit in opposition, it has been mentioned that the respondent number 5, that the private respondent, that is Topon Lohkar, had submitted the copy of the ST certificate issued by the competent authority along with his application, which was verified subsequent to the draw as per the policy and was found to be in order. It was also mentioned that an office order bearing number TAD/BC/855/2013/113 dated 8/4/2014, the Department of Welfare of Plain Tribe and Backward Classes, Government of Assam had declared that the private respondent falls within the category of ST bracket Boro dash Kosari. Taking into account the specific stand of the respondent number 2, 3, and 4 in the affidavit in opposition, and also upon a perusal of the office order dated 4th of August 2018, this court is of the opinion that as the petitioner, as the private respondent belongs to the ST category, and the only basis on which both the writ petitions have been filed, that is, that the private respondent do not belong to the ST category, is totally misconceived. This court does not find any merit in both the writ petitions, and accordingly, both the writ petitions stands dismissed. Pending applications, if any, stands disposed.
I'm sorry, my lord, I just missed the item. I was for item number 100, my lord.
Give your name out there. I've stopped writing names of advocates now. I've just put it in done in court number 1. So in that manner, so give your name.
'95 and '96.
I am for 96, Lordship. This matter has become intractable.
May your lordship be pleased. Actually, my senior is engaged in another matter, so can it be heard? Can the
Which is
matter?
96.
Lordship, 96 WPC number 678/2015.
Let us see what is that. You are appearing 6,
For 95,
95.
yes.
We'll see. 90. Ask your senior to come. 96 is PJ Saikia appearing. What is the matter about?
Lordship, we have submitted a representation. Kindly peruse.
You are the petitioner?
Lordship.
Why you are there?
Lordship, 95 was there.
Then both of you belong there. Oh, the respondent saying, we'll take your matter after that. Get hold of a file, an extra file to detail.
Actually, my senior is engaged in another matter.
I'm not
so-
concerned. You get hold of the file, you argue. I will help you out if you have a case. If you don't have, matter ends. Yes.
but-
Oh, you are saying you're the petitioner,
Lordship, in 96.
Mr. PJ Soikia,
Lordship, I am for K. Borua, Lordship.
Mr. K. Borua. You are K. Borua?
I am P. Borua, Lordship.
P. Borua.
I am appearing for K. Borua, Lordship.
The learned counsel for the petitioner naam to dikhora dibo, huh? K. Borua, where is he?
Lordship, it's not present here, Lordship.
Why you are saying it to be infructuous?
Lordship, since we have submitted a representation that is Annexure D, page 41, Lordship.
Annexure D, page 41. Yes,
And presently we are dealing with
we allow the members of the undersigned to keep certain allied fruit products and other items along with fruits to attract and meet the requirements of the customers. Yes, then
Lordship, now we are dealing with all the products.
where is the GMC? No GMC business. Chalo. Hey, naam to do. The counsel appearing on behalf of the petitioner, to item number 9060, appearing on behalf of the petitioner, had submitted that the petitioners had submitted that the petitioner, which is a, what is that? Is an association.
Lordship, society registered under the society.
That the petitioner, which is an association, registered under the Societies Registration Act.
Lordship,
1860, had submitted a representation on 29/12/2014 before the Commissioner GMC, Guwahati, for allowing the members of the petitioner association to keep certain allied fruit products and other items along with fruits to attract and meet the requirements of the customers. The learned counsel appearing on behalf of the petitioner had submitted that the that the Guwahati Municipal Corporation
Lord.
have permitted the members of the petition association to keep the allied fruit products along with other items, along with the fruits as sought for by the representation dated 29/12/2014. Taking into account the said specific stand, the learned counsel therefore submits that the writ petition has become infructuous. Accordingly, the petition stands closed as it has become infructuous. Yes, madam. Your matter. What is this matter about?
Actually, I'm newly engaged, so I don't have.
Don't worry,
idea.
I'll help you out. Illegal settlement of vendors indulging other than fruit business. Oh,
It's a part-heard matter.
what part-heard matter? There's no part-heard matter. Now, this matter is you are saying that these people are allowing other people to use. Where is your senior? You are there on the other side.
Lordship, in respondent number 4, Lord.
Ah.
Respondent.
So what is their problem? Who are these people? Who are these petitioners? The case of the petitioners are 5 victims of offensive where the 5 the petitioners were evil and they were settled in temporary market after completion of offensive during the year. Allotment orders were issued in their favor and petition number 1 allotted so and so and these rooms are in the ground. We are engaged in various business including vegetable items, stationery items, puja items, decorative items, and the further case of the petition is the standing assessment of market and who were illegally occupying the front page area near the entrance. That's the public notice of public inviting it. Huh? Yes, why are you aggrieved? Do you have anything to say out here? Yes, Mr. Bora.
Lordship.
He is asking that there is some order passed by this court on 18/9/2007 and also in the contempt proceeding. There is that these vendors should not be allowed to remain out there in the L pattern. Any vendor in open L pattern space of Fancy Bazaar Municipal Market and to do any other business other than fruit business in compliance with the direction of so and so.
There are some persons being allotted in L pattern 4 into 4 feet by 4 feet. They will only do fruit business, no other business.
some persons have done business of plastic bottles and papers, and they all they were ultimately evicted from that place.
No, his matter was what?
Lordship, to give permission to sell other article,
You are in El Pattern.
Lordship.
Huh?
Lordship in 96.
Huh?
I am in 96, Lordship.
You are in El Pattern.
Lordship.
Now you say that the commissioner have permitted you.
No, we are now selling all articles, Lordship.
Are they allowed?
No, not only food. Food vending is allowed in El Pattern.
You are who?
Okay,
My lord.
I will order to
Yes,
cut
my
off.
lord.
I will order to cut.
I'm sorry, my lord. I was in another.
No, now I can take it. Earlier, because he was there, he was not there in that matter. So that was, he was saying that matter has become infructuous.
Lordship,
Then
here-
now I can take up. I will order to cut off.
Whatever, my lord, here, my lord, I am for my lord, Fancy Bazaar group of traders, my lord. There are 60 members.
You are in the
there.
El Pattern?
Yes, my lord, I am El Pattern, my lord.
Are you being allowed by the commissioner to do any other business?
No, my lord.
Then what are you asking for?
Lordship, my lord.
Why
I'm
you are
asking for-
saying that the repetition has become infructuous?
Lordship, here, my lord, so some of the members of our association, my lord, was allowed to deal all these articles, my lord. But few members are not allowed to deal with all articles, except only fruits are allowed, my lord.
Yeah.
Therefore, we have filed an application before the my lord, commissioner, my lord, to
In
allow us
95, 96 to
to allow us to deal with all the articles, my lord.
Then
But that representation was not disposed of, my lord. Therefore, my lord, we have filed this present writ petition for a direction, my lord, to the commissioner to dispose of her
Then-
representation, my lord.
then
And
why is your friend colleague saying that it has become infructuous?
therefore, my lord, this case is pending as it is, my lord. And now,
So
we are-
why did Mr. Bonder you say that the matter has become infructuous? Then? Your colleague for who actually appears, he says something else.
No, Lordship. As it started, Lordship.
actually, he thought, my
That
lord,
is why I'm saying I don't allow other people to appear. You didn't have the wakalatnama.
Right.
You shouldn't have done that because tomorrow this order, if this matter was that the connected matter was not there, these people would have been in more deeper trouble. Next time, don't do. You are a young advocate. Be careful. Black book. Yes. Don't next time. Don't do this. That too before this court. Now here the petitioner wants that not to allow any vendor to open L pattern space of earth and to do any other business other than fruit business in compliance. You are not allowing other than fruit business.
Petitioners, they are doing business in the multi-story building. And they are selling some certain products, and these persons, they have been allotted in the L pattern, they will to sell food. This person legally sells all the products that the entire building sells. So their building, sale of their building goes down. That's why they have filed a petition that only the L pattern is allowed for food vending. They should sell only food.
Okay, for food. And there is an order being passed by this court. Where is that order? The members of the petition association shall continue to occupy the space they were allotted to them, strictly adhering to the term. They will not use the allotted space other than the purpose for which the same has been allotted to them. Who are these people? Fancy Bazaar
Yes,
group of
okay.
traders.
And
This is a writ petition.
Lord,
No,
my
no,
lord.
when I think that they have taken that order, they have filed an appeal. That appeal also dismissed, but I can't recall why that.
Now, this order has attained finality.
Lordship.
Then how can you be allowed to do some other work unless you have been allotted?
Lordship, therefore, my lord, we have filed a representation. before
Then
the commissioner,
unless
my
this order remains,
lordship.
so you have to change the order of allotment.
Lordship,
That is why you have requested the commissioner to allow you.
Lordship.
And what is the stand of the commissioner?
Well, they only sell for the food. Nothing else. Madam. They are only allotted allotment letter. This was specific manner only for food vending. 4 feet by 4 feet area was given pattern. And in fact, I can only on recalling my lord, that because against that order, they filed an appeal. Appeal was dismissed. I cannot.
That I admit, my lord.
They filed an appeal against that order. It was
They have filed also contempt.
appeal was filed.
These people have filed a contempt also for whom he is representing. Having heard the learned counsel, I am inclined to dispose of the contempt petition by extending the period fixed in the date dated for its implementation by a further period of 3 months, so as the outer limit and no appeal is filed by the respondent, and no stay is obtained in the order impugned. In other words, if no appeal is filed by the respondent and if no stay is obtained, so Iman and Iman is guilty of contempt. Then notice Dilwar Hussain. Specifically directed the allotee shall not use the allotted space for any other purpose other than which has been allotted. And when upon observe that you are carrying on the business of disposal and not for retail full selling. You are only food selling.
Lordship, my lord.
All these fancy bazaar group of traders are only fruit selling.
Only for selling, my lord, allotment order is there, my lord. Therefore, my lord, we have subsequently approached before the, my lord, commissioner to allow us to deal with other allied articles, my lord. And that representation is, my lord, is still pending, my lord. Therefore, my lord, we have filed this present writ petition for disposal of the said representation.
When the commissioner's stand is here, answering back to state, in order to protect the livelihood of the vendors, ease traffic congestion, allow access to the GMC market, and see on the other, standing committee is to resolve to accommodate the retail food sellers and hawkers in surrounding open space area of Fancy Bazaar, Guwahati. Thereafter, so and so resolved to allow only fruit vendors to occupy the L pattern and one side along the inner reeling road of so and so. That in terms with so and so, altogether 61 numbers of applicants were received, and upon interview, one of the applicants was rejected, being key scholar. All 60 selected food were published on so and so, allotting space of so and so. Is bound by the order dated so and so down due to violation of the relevant resolution and order of the under food sellers here. The ultimately to its association so and so. Upon meeting held on the paper of undertaken to comply with all the terms and conditions of allotment. You have also agreed, submitted an undertaking.
Lordship,
Then why you are doing all these things and filing a repetition out there?
subsequently, my lord, since my lord, other
You change your business, change your place of business, do somewhere else. Mr. Bodler, this court is very perplexed with your conduct. This order you shouldn't have taken. Respondent number 4 is the association. Respondent number 4 is you.
yes, my lord, Fancy Bazaar group of traders.
Not fully correct. The respondent number 4 and 5 are not allotted with any shop in the Iman, and on the other hand, the rest of the petitioners have been carrying on the business in gross violation of the terms of allotment. We are not concerned for dealing with no. Here in the Iman, the members have been carrying on the dealing of selling fruit. However, subsequently, many non-allotted vendors of fruit as well as some cities have forcefully occupied some of the open space and also constructed unauthorized sheds in the same line where the members of the several representations to remove from. This is another thing you are bringing in. The deponent says that the challenging the order dated Iman was to set aside the aforesaid order and directed the fund to restore the inside the relevant to the members of the Iman, and none of the members have been engaged in business other than fruits. And the deponent further states that the statements in so and so are self-contradictory. Your stand in your affidavit is clear. You are only dealing in fruits.
Lordship.
Then why are you asking for something else?
Since my lord, the adjacent road, my lord, that was my lord occupied by the fruit vendor, my lord. Now consumers are, my lord, not attracted to the, my lord, L pattern market, my lord. Therefore, my lord, for survival, my lord, we have, my lord, approached before the, my lord, commissioner to allow us to deal with, my lord, some allied articles of fruits, my lord.
So then, my lord, we
Allied
can-
articles of fruit,
Like
dry
that.
fruits,
like that, my lord.
dry fruits,
Lordship, my-
dry fruits not allowed.
only fruits are allowed, my lord.
Only fresh foods are allowed.
Where
That's
you
the-
mentioned fresh
But
fruit?
they will sell their, what we call this, paper disposable plates and everything.
Oh,
These
that
are-
is not, but dry
These are
fruits.
sold by the person who are holding the stock in the building. So they
Ah.
have come before the court.
Let us see their application. Hmm. Situated on so and so, the customers are not attracted to the shops of the understand. Consequently, the members of the are suffering of conflict. The third is only livelihood for members and so and so. If the members of the understand association are not allowed to keep certain allied food products and disposable items at their respective shops, the members would not be. What is allied food products?
Like, my lord, dry fruits, turmeric, like that, my lord.
Dry fruits,
Turmeric, betel nuts,
betel nut fruits. Fruits.
fruits, sorry, like that, my lord, in package item, my lord.
Yes.
Because, my lord, we are allowed to deal with only fruits, my lord. Now, my lord, the adjacent road, my lord, which was adjacent to the, my lord, GMC, my lord, it was, my lord, illegally occupied by some of the vendors, my lord, food vendors.
And what are you doing with those other illegally occupying people? Anything you are doing? The GMC?
Regularly take exercise of eviction.
Huh?
Eviction is done, taking is done. The moment taking is done, everything comes to hold, things are controlled. But moment that after 2-3 days, they are all back. That's the issue going on throughout the very check. 2-3 days, they will not sell anything. The moment that after some few days they start doing business. All of
But
that.
that means a person who is legally staying, he has no right to sell anything else. But a person who is illegally staying, he can do anything.
These are legally there. They are only to sell food.
Huh?
These persons are there in the alpha to only to sell food. As per the allotment.
But why you are allowing somebody else? You are doing this only asking them for selling of fruits only to protect those who are there in that
No,
particular
This was the allotment. As per
to the GMC market.
But there will be hundreds of other illegal food vendors also. They will face.
No, why you are not taking
Like,
steps
we are
for
taking
this?
steps, man. Every day, each and every time, we are taking steps. But the moment they take step 2-3 days after that, they again take over the street. They are all selling in the illegally on the, especially on the street. The exercise, we can exercise I carry down.
Hmm?
We can exercise I carry down. The foods have been taken, the vegetables are doing business in the area.
You are taking over the vegetable.
Then also, next day they will come. It has become a many things, not in the constitutive.
What is your association? Your association is not doing anything against those people.
But in quantity, my lord, their association is huge, my lord. We are limited.
They have an illegal
Lordship.
vendors association.
Lordship. We are not in a position to, my lord, remove them from the street, my lord. Only because of them, my lord, customers are not attracted to our the GMC market side.
So you are enforcing against them because they are illegal.
Because they have allotment letters to them.
No, you have to take care of something. You see, you are asking them to only sell fruits to protect them. That's the reason. And if they are only selling fruits, you need to also to protect them. You must be taking some money from them on the basis of the allotment.
Yes.
Then why you are not protecting the other side? Them also. You also need to protect them so that the others don't sell fruits. Then only they can survive.
That's why, my lord, we take all eviction exercise regularly. Not that we are taking ideal manner, we take eviction exercise against the all illegal, that is food vendor or the vegetable vendor.
What is
At
the
same
police
time,
doing?
At the same time, my lord, that street vendor tax is there. Everybody takes shelter of the tax.
So they would be better suited without an allotment. Are you better suited without an allotment?
That would have been my lord, but they will, without allotment, they cannot do business in the L pattern. L pattern is the setback of the building. L pattern is the setback of the building.
You are inside that building,
Lordship, compound of the building. Inside the building.
or these people are outside in the road and they are selling everything,
Lordship.
and they don't come to you. You have to take us something. You are the state after all.
That's definitely my lord, we have to take, and that's why my lord, we are taking regularly written exercise. All throughout Century Weather. All throughout Century Weather, we take regular exercise of revision. And particularly this area where the
Are you imposing cost? Throwing them no, do not. You, I think you should impose a heavy penalty. I think that is the only way out. Something has to be done because this is a menace. They would have no other business. Unless you allow them. You can't allow them because of that order.
they have undertaking that will not accept them.
No, the order says to the extent allowed.
Yes.
So you can very well allow. Change the use, change the mode of selling. Something has to be done. Then only they are also can be protected. Something has to be done. If you can't control this menace with the other illegal people, they should be done something, because the order of justice B.K. Sharma does not say anything more than that. It says members of the petitioner shall continue to occupy the space they were allotted to them, strictly adhering to the terms and conditions stipulated in the order of allotment. So you have to change the order of allotment.
The order of allotment, there is strictly saying the only food business will be.
Understood? So if you can, if you can't take care of the menace created by the others, something has to be done.
We take care of this menace in the other side, or illegally doing business. The exercise for to reach those all these persons. All these persons who are illegally doing.
But again, they will come. Something has to be.
It has to be almost a daily event. We have to take action as a daily event, That enforcement has to be done. Otherwise, why not?
No, you see, it is a business. If it is a business, you have to cause them loss.
That's why
So if you allow them and impose them penalty, that is the only loss which can happen. If they are paying 100 rupees, just for example, per day, they have to be paid 1,000 rupees. If they are paying 1,000 rupees, you are safe from the street vendor problem. And with the amount of penalty you are imposing upon them, it will cause a loss for them to continue with the business. Throwing them out, again they will come. You can't keep on throwing them out unless the police is in you with you.
That's another need cooperation from the police.
So either you have to impose fine, a huge fine, so that it does not become lucrative for them to continue, or you have to change it. Because the order of Justice B.K. Sharma is only says to the extent they have been allotted. Now they want a change in the scope of allotment. And their loss, if it is so, they may be given for some other things. If they are selling, don't sell these dry fruit papers and all, but dry fruits. Something has to be worked out. And what is this court is going to do with all this things? Except give you suggestions. Think about it. I'm coming in 5 minutes. How to dispose of the matter. But Mr. Board, very sad.
Okay.
Both the writ petitions being interconnected are taken up for disposal by this common judgment and order. The petitioners in WPC number 4767/2014 are allottees of the Fancy Bazaar Guwahati Municipal Market. And deal and are engaged in various businesses, including vegetable items, stationery items, puja items, decorative items, etc. The grievance of the petitioner in the said writ petition of the petitioners in WPC number 4767/2014 is that the respondent authorities, that is the Guwahati Municipal Corporation, are not strictly complying with the directions passed by this court in the order dated 18/7/2007, passed in WPC number 2254/2007, as well as the order dated 5/12/2012 in WPC number 5390/2012, as well as the order dated 5/6/2014 in contempt case number 103/2013. It is relevant herein to take note of that by the order dated 18/9/2007,
disposing the matter. Actually, what happened while there was a direction of the other of this court, my lord, judgments are there, my to keep the railing free.
Huh?
There should not be any food market inside the railing of the market complex.
that is what I am passing on.
That's all. That is that. For compliance of the order of the court, my lord.
That is what I am saying.
Yes.
Take your seat.
Okay.
By the order dated 18, that WPC number 2254/2007 was filed by an association wherein the petitioners in WPC number 4767/2014 are members. In the said petition was disposed of by an order dated by the judgment and order dated 18/9/2007. Thereby directing the Guwahati Municipal Corporation that directing the government, Guwahati Municipal Corporation, to the effect that while making allotment to the 60 selected applicants, the Guwahati Municipal Corporation will not go beyond the space which the resolution dated 17/12/2004 permits. It further appears that pursuant to the order, pursuant to the said order dated 18/9/2007, a writ petition was filed by the petitioner in WPC number 678/2015 by the petitioner in WPC, which was registered and numbered as WPC number 5390/2012. The said writ petition was disposed of, thereby directing entirely that the members of the petitioner association, that is, the Fancy Bazaar group of traders, shall continue to occupy the space that was allotted to them, strictly adhering to the terms and conditions stipulated in the order of allotment. Semicolon. That the members of the association, that is Fancy Bazaar group of traders, would not use the allotted space other than the purpose for which the same has been allotted to them. And in case of any deviation from the terms and conditions specified in the order of allotment, the GMC authority would be at liberty to take appropriate action in accordance with law. Pursuant thereto, the Fancy Bazaar group of traders filed a contempt proceedings before this court, which was registered and numbered as contempt case number 103/2013. The said contempt proceedings was disposed of by an order dated 5/6/2014. Last time. Order dated demand. Thereby extending the period fixed in the order dated 5/12/2012 for its implementation by a further period of 3 months from the date of the said order, as an outer limit, provided no appeal was filed by the respondents and no stay is obtained to the order impugned therein. It is therefore the case of the petitioners herein, petitioners in WPC number 4767/2014, that the respondent authorities, although were bound by the order dated 5/12/2012 in WPC number were bound by the order dated 5/12/2012 in WPC number 5390/2012 to only permit the members of the Fancy Bazaar group of traders to carry on the business within the terms of strictly to the terms and conditions stipulated in the order of allotment. But the members of the Fancy Bazaar group of traders are carrying on business beyond the terms and conditions stipulated in the order of allotment and are using the allotted space other than the purpose for which the same have been allotted to them. It appears from the records that this court had issued notice the respondent number 2 and 3 had filed an affidavit in opposition on 26/3/2015, stating inter alia that in order to protect the livelihood of the vendors, each traffic congestion, allow access to the GMC market and to maintain pollution-free environment within the market area, the Standing Assessment Market Trade Committee, by resolution dated 1/11/2004, resolved to accommodate the retail fruit sellers and other hawkers in the surrounding open space of the Fancy Bazaar, Guwahati Municipal Corporation Market. It was further stated that the Standing Assessment Market Trade Committee, by another resolution dated 17/12/2004, resolved to allow only fruit vendors to occupy the space in the L pattern portion of one side along the inner railing side of the newly constructed Fancy Bazaar Guwahati Municipal Corporation Market. Pursuant to the resolution dated 17/12/2004, altogether 61 numbers of applications were received, and upon interview, one application was rejected, being tea stall owner. All the 60 selected fruits vendor names were published on 21/4/2007, allotting space of 4 feet into 4 feet, for selling only fruits. It was further mentioned that in a meeting held between the Fancy Bazaar group of traders on 24/7/2014 at the office chamber of the collector GMC, an undertaking dated 4/8/2014 was given by the said association to comply with all the terms and conditions of allotment order issued by the corporation, permitting use of space measuring 4 into 4 in the L pattern within the complex of Fancy Bazaar Guwahati Municipal Corporation market. It was also mentioned in the affidavit that the Guwahati Municipal Corporation have kept strict vigil on the traders to ensure the orders of this court as well as the undertaking dated 4/8/2014 is strictly complied with. Further to that, it has also been mentioned that on 22/8/2014, an eviction operation was undertaken by the Guwahati Municipal Corporation against those violating vendors for violating the orders of this court and undertaking dated 4/8/2014. It is further relevant to take note of that the Fancy Bazaar group of traders, who is the respondent number 4 in WPC number 4764/2014, have also filed an affidavit in opposition in the said writ petition. In the said affidavit in opposition, it was mentioned that the members of the said association have been carrying out the business of selling fruits. However, subsequently, many non-allotted vendors of fruits as well as other commodities have forcefully occupied some of the open area and also constructed unauthorized sheds in the same line where the members of the petition, members of the said association had their allotted space. It was further submitted that the several representations were submitted by the said association before the Guwahati Municipal Corporation to remove the said unauthorized occupants from the said space. However, nothing was done to that effect. It was mentioned that on 2010-2012, notice was issued by the respondent number 2 to the members of the said association directing to dismantle the unauthorized sheds and discontinue the unauthorized business. And thereafter, by the order dated 8/11/2012, the said orders were cancelled and had cancelled the orders of allotment of the members of the said association. Pursuant thereto, WPC number 5390/2012 was filed challenging the said act of the respondent number 2, and this court, by the order dated 5/12/2012, was pleased to set aside the aforesaid order dated 8/11/2012 and directed the respondent authorities to restore back the members of the said association the space which was earlier allotted to them. To the said affidavit in opposition filed by the respondent number 4, an affidavit in reply was filed by the petitioners. It further reveals that WPC number 678/2015 was filed by the said association, that is Fancy Bazaar Group of Traders, wherein the grievance of the said association is that there was a representation dated 29/12/2014 issued to the Commissioner Guwahati Municipal Corporation for permitting them to deal with other allied fruit products and other items along with fruits so that they could maintain their livelihood. It is the non-consideration of the said representation which have resulted in filing of the said writ petition being WPC number 678/2015. To the said affidavit in opposition, to the said writ petition, an affidavit has been filed by the Guwahati Municipal Corporation on 26th of March 2015, wherein it has been mentioned that the petitioner association, that is the Fancy Bazaar group of traders, that the members of the petitioner association, that is the Fancy Bazaar group of traders, cannot have been allotted the space of 4x4 inside the L pattern only for sale of fruits as per the resolution number 2 dated 17/12/2004. And that the petitioner association had submitted an undertaking dated 4/8/2014 to comply with all the terms and conditions of allotment order issued by the corporation permitting use of the space measuring 4x4 in the L pattern within the complex of Fancy Bazaar, Guwahati Municipal Corporation Market. It was further mentioned that the representation dated 29/12/2014 was still pending consideration. In the backdrop of the materials on record, let this court take into account the submissions made by the learned counsels for the parties. Mr. P. Kotoki, the learned counsel appearing on behalf of the petitioners in WPC number 4767/2014, had submitted that the members of the association, that is Fancy Bazaar group of traders, are bound by the order dated 5/12/2012, passed in WPC number 5390/2012, to only carry on the business for the purpose for which the allotted space, for the purpose for which the space have been allotted to them. The learned counsel submitted that if any other allied businesses are being carried out, this would affect the businesses of the petitioners, whose business of the petitioner. That's it. Anything else, Mr. Kotoki?
That's all right.
Will affect the business of yours.
Yes,
As the said petitioners carried out other businesses other than the fruits. Mr. Espora, the learned counsel appearing on behalf of the GMC, on the other hand, submitted that the GMC authorities are keeping a strict vigil in terms with the order dated 5/12/2012, passed in WPC number 5390/2012, and thereby the GMC authorities are not permitting the members of the Fancy Bazaar group of traders to carry on any other business other than fruits. He further drawn the attention of this court that there is even an undertaking being given by the Fancy Bazaar group of traders dated 4/8/2014 to the effect that they would not carry out any other business other than for the purpose of which the space have been allotted. The learned counsel further had submitted that on the other hand, Mr. K. Borua, the learned counsel appearing on behalf of the Fancy Bazaar group of traders, that is the petitioner in WPC number 678/2015, had submitted that the members of the petitioner association of the said petitioner association are carrying on the business of fruits. However, in view of the inaction of the GMC in controlling the minutes of unauthorized and illegal vendors, who are doing similar business on the roadside of fruits and other allied businesses, the entire business of the members of the petitioners association have been affected, and thereby the representation have been submitted so that the terms of allotment could be changed, thereby permitting the members of the petitioner association to carry out the business of fruits as well as allied fruit products and other items along with the present business. This court made a specific query upon the learned counsel appearing on behalf of the GMC as to whether there is any other illegal vendors who are carrying on similar business to what the members of the Fancy Bazaar group of traders are carrying on. The learned counsel for the GMC, with all fairness, had submitted that there are certain illegal trader business and illegal vendors who carry on such business. However, the GMC have been taking appropriate steps from time to time. He, however, submitted that yes, Mr. Bora, what do you have to say?
No, we take regular exercise of eviction, illegal.
Then, and further,
And my lord, we will continue to take my because they will.
the learned counsel further submitted that the GMC authorities are taking regular action against those illegal vendors and would continue to take such measures so that the business prospects of the members of the Fancy Bazaar of the association, that is Fancy Bazaar group of traders, are not affected. I've heard the learned counsels for the parties and given my anxious consideration to the matter. From the perusal of the materials on record, as well as from what appears from the contentions, it transpires that the business of the members of the petition of the association, that is the Fancy Bazaar group of traders, is confined to fruits, selling of fruits, and the allotment of space have been granted only for selling of fruits. The order dated 5/12/2012, passed in WPC number 82, have also attained finality. And as such, the members of the association, that is the Fancy Bazaar group of traders, cannot carry out any other business other than for the purpose for which the space have been allotted, unless and until there is a change being made by the GMC authority. This court cannot also be unmindful of the fact that if illegal vendors are allowed to street vendors are allowed to carry on the business within the vicinity of the business being carried out by the petitioners in both the writ petition their rights, their business prospects would suffer. Under such circumstances, this court is of the opinion and accordingly directs the respondent GMC authority to take appropriate steps so that what is that? How do you take care of the street vendors? What is the right of the street vendors out there?
From 14X discount. Then they have to now they have to give I-card. There is for once it had been done, my lord. There were 7,800 of people had been already been numbered. And now that period had lapsed. Now no new survey is going on.
Are you still allowing those people to be there in that vicinity, in that road, in front of the GMC market?
There, today's instruction I don't have it, my lord. But still, my lord, there are certain things going on in and around, my lord. Because in and around that vending is going.
Now, if you allow them the vending of
No,
everything,
we are not allowing. They are all illegally doing it, my lord.
if they allow, if you don't
That's why, my
take
lord,
care of the illegal vendors, then how will they survive?
Well, that's why we will take an exercise again, my lord, to evict all these persons by doing illegal.
Eviction, you have to take on a Regular basis.
Regular basis, man, we already I have instructed them to take, agency to take eviction regular basis. Like, it has not only problem to the petitioner, it has become almost a menace to everywhere, man. On the footpath, pedestrian kind of work, which has come in everywhere, man. Not only on festival.
Illegal locking. Take appropriate steps that so that the menace of the illegal street vendors within the vicinity of the Fancy Bazaar Guwahati Municipal Market are taken care of. It is further observed that if such action, it is also observed are taken care of by resorting to regular eviction rights so that the business prospects of the petitioners in both the petitions are not affected. Anything else?
That's all, my lord, actually. I'm afraid it's all, my lord.
Because I can't allow you to consider their case. Because that has already attained finality. But can I give a direction to the effect that if the GMC is not then to consider your representative?
That may be my lord. In the meantime, my lord, what's happening? I checked up the record, my lord. They have, the president told that against the order, file a writ appeal of 93 of 2013. It was disposed on 29/4/2000, upholding the like single judge order.
Huh?
Upholding single judge order.
No, that I've seen. It is there in the order.
Otherwise, practically, my lord, if we go, my lord, every day, my lord, they are, my lord, doing their business.
It is further mentioned that in the circumstances the menace of illegal traders cannot be controlled by the GMC. The representation dated 29/12/2014, which is still pending before the respondent, before the commissioner GMC, shall be taken into consideration, and the commissioner GMC shall pass appropriate orders with above the petition. Pending application.
Total disposal.
97.
None appears on behalf of the petitioner. It appears on the record that it appears from the affidavit in opposition filed by the respondent number 3, 4, 5, 6, and 7, and more particularly annexure 1 to the affidavit in opposition, that the instruction, that the information which was sought for by the petitioner was duly furnished by the communication dated 24/2/2014. Accordingly, nothing survives in the instant petition for which the petition stands closed on stands closed.
The word is 98.
The case of the petitioner hearing is that the petitioner took a policy, opened a critical care policy from the ICICI Lombard General Insurance Company Limited. The said policy was covered for the period from 28/3/2012 to 27/3/2013. It has been stated in the petition that all the material information was supplied at the time of taking the policy. It has been alleged in the petition that the policy was enforced. While the policy was enforced, the petitioner suffered CVA, bracket SMIC, ISHEMIC, bracket close, in right-sided hemiparesis, HEMIPARESI, on 4/1/2012. Of 4/10/2000. Although the petitioner had no knowledge about his ailment at the time when the petitioner had no knowledge about had suffered CPA ischemic in right side hemorrhage on 4/10/2012. The petitioner took treatment at Jorhat initially, and thereupon the petitioner was admitted to the Guwahati Assam Medical College on 6/10/2012. The petitioner thereupon continued to undergo treatment at Assam Medical College till 9/10/2012. Thereupon, the petitioner sought for treatment, lodged the claim before the manager, PA Claims Public, respondent number 4 for 6 lakhs by claim number GEN, all caps, CIDA 075681. The said claim was repudiated by the respondent ICICI Lombard Insurance Company. On the ground of concealing pre-existing disease. The petitioner, being aggrieved, approached the insurance ombudsman However, the insurance ombudsman, by an order dated 1/11/2013, observed that the petitioner suppressed the material information regarding his illness at the time of filling in the proposal form. And as such was guilty of non-disclosure of material facts and thereby violated the principles of contract of insurance by not maintaining utmost good faith. It is under such circumstances that the insurance ombudsman held that the insurer had rightly repudiated the claim of the above policy and no interference was called for. It is against the said order dated 1/11/2013 that the present petition has been filed for setting aside the said order dated 1/11/2013 and for a direction upon the insurance company to pay an amount of rupees 6 lakhs as compensation to the petitioner. It appears from the record that the insurance company, that is the respondent number 3, 4, 5, and 6, have jointly filed an affidavit stating inter alia that the writ petition involves disputed questions of facts, and as such, the same cannot be adjudicated by way of proceedings under Article 2 to 6 of the Constitution. It has also been mentioned that the insurance claim was rightly repudiated in view of the suppression of pre-existing disease. It further appears that the respondent number 2 had also filed an affidavit supporting the decision dated 1/11/2013 It is relevant to take note of that in paragraph 4 of the said application, said affidavit, it was mentioned that the documents of the petitioner, like Dr. Upaidhyay's prescription dated 14/2/2010, reveals that Narayan Upaidhyay advised that Dr. Narayan Upaidhyay advised the petitioner to do ECG and CT scan of brain only for doubtful convulsion, and the petitioner did the CT scan of the brain in TM Hospital Private Limited, Dibrugarh, on 14/2/2010, and the results of the ECG showed all normal. Paragraph 4 A perusal of the materials on record therefore reveals that the question as to whether the petitioner had disclosed the pre-existing disease at the time of filling on the proposal form is a question of fact, or for that matter as to whether the petitioner had a pre-existing disease at the time of taking the critical care insurance policy. These aspects of the matter cannot be adjudicated by way of a writ petition. And accordingly, this court is of the opinion that the instant writ petition cannot be entertained. However, this court is also of the opinion that if the petitioner is aggrieved, the petitioner can very well approach the consumer forum or the civil courts, claiming entitlement on the basis of the state policy, wherein the facts could be adjudicated on the basis of evidence. With the above, therefore, this court is not inclined to entertain the instant writ petition. In view of the above, this court is not inclined to entertain the instant writ petition. However, liberty is given to the petitioner to approach the appropriate forum, and the time and the period during which the instant writ petition has been pending, that is from 22/9/2014 till date, shall be excluded while computing the period of limitation.
$99.
That matter may kindly be taken up on Thursday, Lordship.
Bye.
My senior, Mr. T.J. Mahanta, is appearing in this case. Lordship, this is an engaged matter. However, the engaging counsel has left practice.
Well.
He has some difficulty today, Lordship.
Well, difficult. Inquiry report. Pollution control. Set aside and cost of disorder dated past for the PC of the issued inquiry report. What is there? Any stay? Honorable. What is there? What do you mean? Challenging with what?
Petition control order.
Huh? Withdrawal.
No. Case 52.
8.
52. An extra profit of the registration.
Allowed to accept So this somebody is challenging this order
Lord.
of stone crusher.
Lord.
Who are you?
It is not with
Oh, you are appearing without a brief. That the other person is functioning. Okay. The learned counsel appearing on behalf of the petitioner seeks for an accommodation. We don't pass an order today.
not okay.
Yes, Mr. Professor, you are sitting. What matter? What is that?
I'm waiting for my lord making a request for my lord some accommodation for this.
Why?
My lord, at number one, my lord, brief is not with me because the advocate who engaged me, he is absent today. And he made a request, my lord, to kindly to watch the matter and make appropriate report. And I'm sorry, extremely sorry, my lord. This is the reason, my lord.
Anybody else who wants to? Yes, Mr. Bhagwati. Huh? Okay. Next
My lord,
item.
this matter may be taken up on Tuesday, my lord.
Which one?
Item number 108.
Oh, yeah, I can't say. You see, today I was free. I was only given 11 matters. So that I could finish up those 11 and now they started with me. Taking these matters is very difficult.
No, these matters are regarding my lord, the overloading of wagons, my lord. Overloading of wagons, railway wagons. One of the petitioners, they book goods at the Bhapi station in Maharashtra, my lord. But there are no way bridge out there. So the first station they get at Nandapur, they weigh this.
Who are you?
I'm for the railways, my lord.
Railway.
But I have filed it.
India, the transporter railway shall be to allow manual re-equipment of
My lord, that prayer is already met, my lord, because since 2017, my lord, we have a in motion weighing bridge at New Guwahati. So if they ask, they can always make their
now.
revenge.
This is in respect to that consignment only.
My
or
lord.
is it every time? Is regularly transferred perishable milk products and medicines, etc. from Bhapi, Gujarat to New Guwahati. Since there is no facility for weighing of goods at the originating station Bhapi, the weighment is done at the in-motion weigh bridge at the Maharashtra. The result of the in-motion is sufficient. The lens refers to 10 instances to reflect the serious deterioration. The excess weight was noticed in the weighment done at the because of this. The case of the learning that the weighment the resistance can be helpful to people here. Video the one that notice the case of the liquid shall allow me to weighment of. Now what do you want? What is the
No, my
prayer?
lord, their prayer, my lord, is at page 46, my lord.
Yeah.
They want that the revailing has
directing the respondent to allow reweighment of the goods on the application submitted by the petitioner paying for the to buy reading the
my lord, previously what had happened, my lord, in 2013, 12, 14, we did not have this way bridge out here in Guwahati. So if they file an application for reweightment, my lord, again has to be taken to New Bongaigaon for reweightment. So as per the policy, my lord, second reweightment was not allowed. But nowadays, my lord, that is not the case. My lord, since 2017, we have this electronic way bridge in New Guwahati. So whenever they make an application, my lord, the second reweightment can be done, my lord. So that prayer is met, my lord. In fact, there's nothing left in this. And only one prayer is that, my lord. They said to close down the way bridge in Nandapur, my lord. But the thing is, my lord, there are hundreds of trains flowing through that, my lord. So just watch it go through the prayers that they have made it. The most important prayer for reweightment, my lord, that is our claims. Since
Where is
then,
the
my lord,
counsel for the petitioner?
Mr. B. Gogoi really appears in these cases, my lord. Mr. B. Gogoi.
B. Gogoi,
Udra
where is
Gogoi,
he?
my lord.
Not where? Miss N. Bortolo, who is there?
They're juniors, my lord.
None of the, none of the, any of it, anybody is not there. I know anybody B. Gogoi, B. Nag, and Sakuria.
Nothing is there in this reputation right
So I
now,
will
my
close it down. They are not there, no problem. Then also I'll close. Then they go and file a plea. Because I don't close it for district 44. No one married. 2014 matter, and then again for restoration, again it comes up.
That's true. That's true, man.
It makes no sense. No? Like just 2 matters before you saw about the insurance policy. Insurance policy was rejected in 2013.
Almost 10 years.
10 years have gone by. Now, if today I am going to again dismiss for default,
Again,
and
there's
then
a
again-
restoration petition.
and these are disputed questions of fact, I can't decide. So better off dismiss it and then go to and giving them the liberty. If you want, you can fight. And the period in which the petition has been pending has been kept. That is the only way. Because if I keep on doing this, it will matter. And
In
getting
fact,
hold
my lord,
of
most of the old cases, my lord, have already become infectious, but still pending.
any of the matters have become infected. Bench 4 has become infected many matters, but bench 3, no.
No, but bench 4 matters, my lord, because of settlement
There
and
are a
all
lot
those
of
things.
matters,
my lord.
and more particularly those, most of the disciplinary proceeding matters, maximum disciplinary proceeding matters where rules have been issued, nothing has been done, all this. Today I finished up 7. No. Those are all 2011. Three things that out of 3 things, 3 penalties, 2 have already become infected.
Lordship may take up on Thursday, my lord.
No,
one
Thursday I don't get time. No, if I remember, to me the Railways Act. Railways Act says there is a scope of payment is there, but you have to pay the
money.
Do they want it without payment?
But my lord, actually, that is with regard to the, my lord, these wagons, my lord. These are all parcel vans, my lord.
It will depend on what type of wagons are there. Na?
Right.
At one point of time, I have to see. Where we can make the request made by the consignee or the consignment subject to
My lord, in fact, in this case, my lord, when they found that their train was overloaded, they were requested to offload the goods, my lord. They refused to.
Now, is there any demand?
There's a demand, my lord.
Then what happened? What happened to
Because
the
of the
reweighment?
interim order, my lord, that is.
So
not
what have you
recovered
done
from
as
that.
regards the reweighment? If there is a
Rearment
demand.
has been done, I think, my lord.
No, they have not challenged the demand.
No.
Then
The prayer is, my lord, that the respondents allow the rearrangement of goods upon application. And secondly, respondent to issue notice.
no, there is an affidavit filed by respondent.
I have filed.
Yes. What have you stated out here? Now, have you stated out here?
But the main allegation in this case is that, my lord, the way bridge at Nandubar was not working properly, my lord. Regarding that, my lord, they have not submitted anything. But, my lord, the railway says that, my lord, every year, my lord, the weights and measure departments, they issue certificate regarding the fitness of the way bridge. So we said that, my lord, the payment that was done, my lord, it is correct.
There is a test certificate.
My lord. That page 24, my lord. 23, in fact, this certificate, as of 2014. In this type of case, my lord, in fact, all the cases, the only excuse is that, my lord, the way bridge was not working properly. Most of the cases.
As the in-motion waivers are certified by the concerned department of the state government from time to time. Second waiver should not be permitted on parties' request. What does it mean? Kindly come to page 28 of your affidavit.
Page, my lord.
27.9.
My lord, that's a circular, my lord.
Now, what I don't understand. As in the motion, in-motion waivers are certified by the concerned department of the state government from time to time. Second waiver should not be permitted on parties' request. Now, isn't that contrary to 79? A railway administration may, on the request made by the consignee or the endorsee, allow payment of the consignment subject to such conditions and on payment of so and so as may be prescribed in the demurrage charges if any, provided that except in cases where a railway server authorized in his behalf considers it necessary to do so, no payment shall be allowed to the goods booked at owner's risk,
My lord, these are all goods booked at owner's risk, my lord.
which are perishable and is likely to lose weight in transit, provided further that no request for payment of air in vegan or air shall be allowed if the payment is usable to possession in the yard or such.
My lord, what happens, my lord? The load, my lord, these wagons, they are loaded by the, my lord, consignee. And they make a statement that this is 100 kilos. And we issue a receipt saying that, my lord, sender's weight accepted. We do not measure it. But
It
what
is
happens
given
during transit, my lord, when it is measured, then we find that this is overloaded.
Loading party, loading by party, loading not revised by so and
Railway
so. This
staff.
is under 63,
My lord, 65.
60 or 65. Huh? Owner's risk,
5. If I'm not wrong, my lord, 65.
65. No, this is a railway receipt. Yes. In case where the goods
Well,
are to be loaded by person entrusting such goods on the completion of such loading, there will be primarily evidence of the weight and provided that in case of a consignment in
wagon load or train load,
and the
weight of the number of
such
is not checked by the railway servant.
statement in
Instead, the effect is recorded in such railway receipt. The burden of proving the weight or any case may be shall lie on the consignee or the endorsement.
state to consent. No, nobody.
No, nobody's there.
Yeah.
You will request me to for adjourn the matter for today.
What?
You will requested me to adjourn
For today.
by today.
Come at 10:30 to what? We'll take it up. 10:30. Ask Mr.
Actually,
Gangwal. First time.
Money